Supreme Court of the Philippines shall give their attention, for the court is now in session.
The clerk of court will please call the matter plan.
GR number 221697, Mary Grace Natividad S. Poe-Llamanzares versus Commission on Elections and Estrella C. Alamparo, and GR numbers 2298700, Mary Grace Natividad S. Poe-Llamanzares versus Commission on Elections, Francisco S. Patay, Antonio P. Contreras, and Amado D. Valdez. Appearing as counsel for petitioner are Attorney Alexander J. Cobrador, Attorney Dino Vivencio A.A. Tamayo, Attorney Justin Christopher C. Mendoza, Attorney Sandra May T. Magalang, and Attorney George Erwin M. Garcia. As counsel for Public Respondent Commission on Elections, we have Commissioner Arthur D. Lim, Commissioner Maria Rowena Analagui Gansones Natural. For private respondent, GR number 221697, with Attorney Estrella C. Alamparo. As counsel for private respondent, Francisco S. Patad, in GR numbers 22169A to 700, Attorney Manuelito R. Luna. As private respondent, Dr. Antonio P. Contreras, in GR numbers 22169A to 700, Dr. Antonio P. Contreras. As counsel for private respondent, Amado D. Valdez, in GR numbers 22169A to 700, Attorney Amado D. Valdez. Attorney Mercedes Marcos N. Valdez II. Attorney Donna S. Agoncillo, Natural. Attorney Mark Andrew M. Santiago, Natural. And then we have Attorney Lawrence Angelo G. Dionisio. From the Office of the Solicitor General, we have Solicitor General Florin Tinilbay as Tribune of the People.
And counsel may please remain standing. In order to expedite things, we are going to first, before we proceed with the interpellations, request private respondents, the four private respondents, to successively give their oral presentation for 5 minutes each. As earlier understood, then the Solicitor General will have 20 minutes, then we resume the oral interpellations. So, Commissioner Gill, in the meantime, rest a while. Thank you. All others, please take their seats while we will have the first private respondent present their arguments.
Good afternoon, Your Honors. This case is not about all foundlings. Not all foundlings are the same. In the case of some, the identity or at least nationality of their mothers can be traced, like the Duncan and Ellis cases. Not all foundlings renounce their citizenship and choose to become naturalized Americans, thus further jeopardizing their eligibility under RA 9225. Not all foundlings abandon their domicile of origin, as what petitioner did. Finally, not all foundlings run for office and make material misrepresentations in their COCs. So let's not unnecessarily drag all those whose parents are unknown into this case. This case is only about one person, and the unique facts surrounding her. Unfortunately, this one person failed to submit any evidence whatsoever to prove the possible identity or at least nationality of her biological parents. The allegations as to her height, phenotype, and even the probability of foreigners being in Iloilo in 1968 were just allegations. Not a single shred of evidence, not even an affidavit, was presented to prove the same. Indeed, it would be unfair to expect respondent Comelec to consider and discuss in its decision any imaginary evidence or one that was never presented. Petitioner has no one to blame but herself by anchoring her claim of being natural born solely on a non-existent assumption under international law. Having chosen not to present even an iota of proof on such a crucial factual issue, respondent Comelec merely decided on the basis of law and the remaining undisputed facts. That is nowhere near grave abuse of discretion. The 1935 Constitution is clear as day. Since petitioner is claiming to be natural born, not just a citizen, she is not invoking items number 1, 2, or 5 in the enumeration of citizens. She is invoking numbers 3 and 4, the use sanguinis provisions. The natural-born requirements that citizenship must be from birth and acquired without having to perform any act evidently applies only to these use sanguinis provisions. Clearly, natural-born under the Constitution requires bloodline. It is therefore incongruous to insist that another category, that of foundlings, who were intentionally excluded by the 1934 CONCON, are actually deemed included among the use sanguinis provisions and therefore natural-born. Foundlings cannot possibly qualify under use sanguinis precisely because of a known parentage. It defies logic to force their inclusion in that category, whether by presumption, implication, or some other legal artifice. To force the issue would be to do violence to the Constitution. Without a constitutional amendment, the only logical item in the enumeration where foundlings can be deemed citizens is through naturalization. Unfortunately, as we have pointed out, petitioner vehemently refuses to be classified as naturalized. Among the international conventions mentioned by petitioner, we only ratified 4, and 3 of these only recognize the right to acquire a nationality. No mention is made of foundlings nor natural-born status. The thesis of petitioner is that although the statelessness conventions were never ratified, the norm embodied therein is nonetheless customary law or generally accepted principle of law. This is untenable for the following reasons. Number 1, the statelessness conventions merely speak of grant of nationality, not the grant of natural-born status. Number 2, while the 1961 convention speaks of a presumption, the acquisition of nationality will not be automatic from birth, because not all those found within a territory will be considered foundlings. It has to be established that their parents are unknown. Thus, there has to be a proceeding somehow, no matter how summary, to ascertain that fact. Number 3, even if the 2 conventions had granted natural-born status, this norm can still not be considered customary law or generally accepted principle because of the absence of widespread state practice, and they are not binding on all civilized states. Number 4, even if we assume arguendo that there is a generally accepted international norm granting natural-born status to foundlings, the same can only be equivalent to municipal legislation and can never trump our Constitution. Equally important but often overshadowed is the issue of residency. Petitioner is not a 10-year resident. The Honorable Court has uniformly declared in Osato-Reyes, Coquilla, and Caballero that the earliest possible reckoning point for domicile in cases of Filipinos who became foreigners is upon the acquisition of citizenship under RA 9225. In Osato-Reyes, petitioner even served as provincial administrator prior to the acquisition of citizenship, but the Honorable Court said no amount of stay can substitute the fact that she had not reacquired citizenship. The only possible exemption to this rule would have been had petitioner secured a permanent residence visa as held in Coquilla. The 2012 COC binds petitioner for the following reasons. Number one, it evidences intent. Number two, it is an admission against interest. Number three, it is a notarized document entitled to full faith and credit. Number four, the COC declaration on residency, to the effect that she began residing here in November 2006, is perfectly compliant with the rule requiring the acquisition of citizenship first. Finally, the intent to mislead is glaring in this case. She knows she does not comply with the natural born requirement when she accomplished her COC because she was faced with the exact same requirement as early as 2006. In 2006, when she applied for dual citizenship under RA 925, which also required her to be natural born, she was already informed that she had to be born to Filipino parents through the form provided by the BID. When she received the BID order, she was informed that her petition was granted precisely because of her misrepresentation that she was born to her adoptive parents. Consequently, when she accomplished her 2012 and 2015 COCs, she already knew that she was misrepresenting because she was faced with the exact same requirement way back in 2006. Petitioner also definitely knew that she did not comply with the residency requirement because it was her own deliberate and considered choice not to get a permanent residence visa in 2005. That was her conscious decision. Instead, she opted to come back here as a temporary visitor under the Balikbayan program with a limited duration of stay. Not to mention the fact, of course, that the 2012 COC, which she had executed, confers her knowledge upon compliance. In closing, Your Honors, in my petition before the Comelec, I started with a plea for certainty. Certainty as to the qualifications of this particular presidential aspirant. To this very day, all she can offer are most likelies and most probablys. To rule in favor of petitioner, the Honorable Court would have to cut the proverbial Gordian knot with judicial legislation when said knot can in fact be easily entangled through the simple application of established law and jurisprudence. The law in this particular case is neither silent nor obscure. Everyone, including petitioner, has to learn to respect and follow it. Thank you, Your Honors.
Thank you, Terlena. Para Attorney Luna.
Honorable Chief Justice, Senior Justice, and Associate Justices, may it please the Court. In applying the provisions of the Constitution to the cases at bar, may this Court abide by its own ruling in the case of Poe-Llamanzares versus Comelec, wherein it was pronounced by Justice Carpio, this Court is sworn to uphold the Constitution, apply its provisions faithfully, and desist from engaging in socio-economic or political experimentations contrary to what the Constitution has ordained. The judicial power does not include the power to rewrite the Constitution. Philippine citizenship cannot be treated like a commodity that can be claimed when needed and suppressed when convenient. In the case of in re-application for admission to the Philippine Bar versus Vicente D. Ching, who was born during the effectivity of the 1935 Constitution, this Honorable Court denied Vicente Ching, who passed the bar examination, and his mother is a Filipino citizen with privilege of being recognized as a Filipino citizen. In the United States versus Wong Kim Ark, decided in 1898, the U.S. Supreme Court pronounced the right to determine rules on admission to citizenship is considered an aspect of sovereignty. In Villahermosa versus Commissioner of Immigration, it was ruled that mere birth in the Philippines of a Chinese father and a Filipino mother does not ipso facto confer Philippine citizenship, and that jus civilis instead of jus soli is the predominating factor on questions of citizenship, thereby rendering obsolete the decision in Poe versus Collector of Customs in the U.S., Lim Bin, and similar cases. Contrary to petitioner's claim, neither the Domestic Adoption Act of 1998 nor the Inter-Country Adoption Act of 1995 bears Philippine citizenship to founders. A plain reading of sections 16, 17, and 18 of the Domestic Adoption Law will show that the effects of adoption are limited to the severance of legal ties between the biological parents and the adoptee, that the adoptee shall be considered a legitimate son or daughter of the adopter or adopters. In legal and intestate succession, the adopter or adopters and the adoptee shall have reciprocal rights of succession. To permit acquisition of Philippine citizenship by adoption may subvert the strict provisions of the naturalization law, apart from contravening the fundamental law of the land. In Manila Prince Hotel versus GSIS, was held, if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch, or entered into by private persons for private purpose or purposes, is null and void and without any force and effect. In the United States, both federal and state law provide that the adopted alien must first be naturalized to become a citizen. Under the French Code, it's provided that the adopted retains his citizenship, notwithstanding his adoption by a foreigner, nor does a foreigner lose his citizenship by being adopted by a Frenchman. Although an adopted child has the same rights and duties as a legitimate child of the adopter, this must be understood to be only civil rights and duties, but not political rights. COC cancellation proceedings are governed by Section 78 of the Omnibus Election Code as effectuated by Rule 23 of the Comelec Rules of Procedure as amended by Resolution Number 9523. On the other hand, disqualification cases against candidates for national positions are governed by Section 2, Article 7 of the 1987 Constitution, which is self-executing. Moreover, the Comelec has the power to declare a candidate a nuisance candidate, and this applies to national and local candidates as well. So, it is absurd to say that the Comelec has no jurisdiction over national candidates on questions of qualifications. Petitioner's invocation of Section 2 of Paragraph 2 of the Charter, therefore, is erroneous since an election contest contemplates a post-election scenario. This has been clarified by the Supreme Court in the case of Texan versus Comelec, that ordinary usage would characterize a contest in reference to a post-election scenario. The cases against the petitioner before the Comelec were all filed before the election, and therefore the scenario was pre-election, and these cases are definitely within the cognizance and jurisdiction of the Comelec. In Domino versus Comelec, public respondent Comelec disqualified the candidate for the Long District of Sarangani for lack of residence qualification. The Honorable Supreme Court held that contrary to the claim of intervener, petitioner was not notoriously known by the public as an ineligible candidate, although the resolution declaring him ineligible as a candidate was rendered before the election. The Comelec, under its rules, may even liberally construe its rules and even suspend them in the interest of justice. In exercising its power and jurisdiction as defined by its mandate to protect the integrity of elections, the Comelec may not be straitjacketed by procedural rules as ruled in Caballero. Suffice it to state that Rule 23, Section 8 of the Comelec Rules of Procedure does not violate Section 7, Article 9A of the Constitution, neither is it contrary to Section 3, Rule 64 of the Rules of Court. The Comelec would not usurp the jurisdiction of the Presidential Election Tribunal when it ruled on post-eligibility to run as President. Neither is the Commission precluded from determining whether petitioner is a natural-born Philippine citizen, notwithstanding the SEC's November 17, 2015 decision in case number 001-15. Under Section 52C of BP 881, the Comelec is mandated to promulgate rules and regulations implementing the provisions of the Code or other laws which the Commission is required to enforce and administer. And in case of conflict between rules, regulations, orders, and directives of the Commission in the exercise of its constitutional powers, and those issued by any other administrative office or agency of the government concerning the same matter relative to the elections, the former members of the Undeniably, the 1935 Constitution does not favor the cause of the petitioner, and therefore, the Honorable Court is respectfully pleaded to dismiss your petitions because there is not grave abuse of discretion on the part of the Comelec in disqualifying her or cancelling her certificate of candidacy for the presidency. Thank you.
Thank you, Dr. Contreras. So, Attorney Valdez already was slated to speak next. You may proceed.
Madam Chief Justice, Senior Associate Justice, the Honorable Associate Justices of the Supreme Court, on behalf of the Lodins and the legal community, we welcome Justice Kabila. Allow me to quote Marcos Aurelius' reflection on citizenship. When the branch is cut from its neighboring branch, it is necessarily cut away from the whole tree. In the same way, a citizen who severs her ties from her country has severed herself from the wider society of fellow citizens. The branch which stays with its tree from the beginning of its growth ensures its transpiration is not the same as the branch which is cut off, intently grafted, whatever the gardener says. Justice Ronan, it was Marcus Aurelius. When you said justice means giving everyone is due, thus what is due to the branch that stays with the tree is different from what is due to the branch which is cut off. Senator Poe, the cut-off branch is not a natural born citizen, assuming she was one after her renunciation of her citizenship. Applying the rules of evidence, the Comelec found that she is found guilty. These same rules cannot say that she is or she is not a natural born citizen. In that context, the Chief Justice is right about impossible conditions. And Justice Martineza is right in ruling out conclusive presumptions. That is why we refer to the 1961 UN Convention, which presumed her only national of the Philippines. When her adopted parents failed to find her natural parents, they adopted her under the law of the Philippines as a presumed national, not as a natural born citizen. Ms. Poe likewise recognized her presumed Filipino nationality by admitting being a foundling. That presumption allowed her to have a home, parental care, in the protection of society and family. Neither her adopted parents nor Ms. Poe can now deny her presumed Filipino nationality and claim a natural born citizen. Because nationality in international law means one belongs to a country. You will never see in the conventions about the word citizenship. It's only about nationality. Because citizenship refers to the status conferred by a country to a person to enjoy certain privileges. Mere birth in the Philippines, as you heard in Bella Hermosa, does not ipso facto confer Philippine citizenship. When Ms. Poe was presumed a Filipino citizen, she should have treasured the privilege as a pearl of great price. The gift was gone when she renounced Filipino citizenship in 2001. It was done because she renounced it. She abjured it. The definition of a natural-born Filipino citizen is one who does not make a specific act to acquire it perfectly. Ms. Poe had to perform an act to reacquire Philippine citizenship in 2006 and another act to perfect it by renouncing her U.S. citizenship in 2010. The indispensability of renunciation is underscored in the highly inspired Makiling decision in the perceptive Subihana versus Condon. RA 9225 by necessity is applicable to all. For example, when we say that Ms. Poe is a natural born under RA 9225, shall we allow in the future a natural born Filipino who renounces his status, becomes a Syrian citizen, joins the ISIS, or becomes a Chinese citizen, reacquires natural born status, then elected president only to surrender the West Philippine Sea to a foreign power? Senator Poe's 10-year residency is also false. In the light of Tuquilla, in the light of Lacson, in the light of Caballero, in the light of Calosmo's decisions. In Reyes, you said that no amount of restraint the Philippines can substitute her domicile prior to her reacquisition of Philippine citizenship. Petitioner's failure to renounce U.S. citizenship in 2006 and representing herself as a U.S. citizen in at least 5 times show the absence of animus non revertende to her U.S. domicile. By applying the highly nationalistic Honduras strict process on dual allegiance, the Comelec acted liberally in counting her residency from July 2006. Your Honors, Respondent Comelec did not abuse its authority, did not act in excess of its jurisdiction in finding as false petitioner's material representation about her citizenship and residency. Thank you very much, Your Honor.
Thank you, Attorney Martinez. Dr. Contreras.
Honorable Chief Justice, Honorable Associate Justices of the Supreme Court. There has been so much talk about petitioner being an abandoned child among parents and how we should accord her fairness by granting her natural-born citizenship by mere probability. Your Honors, please allow me then to shift to the reality of the petitioner as one who abandoned the Philippines as her country of nationality in 2001 and now has the audacity to demand special treatment. She insists that she should have automatically reacquired domicile in our country when she arrived as a naturalized American citizen on a temporary visitor status in May 24, 2005. Petitioner has to be told that she is not special and above the law. Your Honors, this court has ruled and guided, kaasi, kaskante, and obdurasyon that Filipinos who have not been naturalized but have already acquired permanent residence in the U.S., which in kaasi you have considered to have amounted to a loss of Philippine domicile, have to formally execute an act of surrendering their green cards in order to validly reacquire domicile in the Philippines. It will therefore not be more justice if physical presence and intent to reside in the country were not enough for those who never abjured their loyalty and allegiance to our country, while mere arrival and possession of intent are enough for petitioner who willingly renounce our republic. Petitioner failed to establish a domicile in the Philippines in May 24, 2005, for the simple reason that there is no proof that on that day she formally abandoned her domicile in the United States. This honorable court has already settled that one can only have but one domicile at a time. There is also no proof whatsoever that petitioner was a registered resident alien after her arrival in May 2005, prior to her acquisition of dual citizenship. It is also the ruling of this honorable court in Coquilla that foreign nationals have to obtain the necessary documents to waive their non-resident status in the country. Thus, aside from failing to establish a domicile in the country upon her arrival, petitioner could not also claim to have established such any time prior to July 2006. Your Honors, petitioner insists that she has no intent to deceive and mislead. Your Honors, Section 78 of the Omnibus Election Code does not contain any reference to intent to deceive or mislead as an essential ground to cancel a COC. It was only in jurisprudence that this element emerged. In fact, not all Section 78 cases were decided on the basis of a clear determination of the presence of intent to deceive or mislead. It was not cited in Oxiaco Reyes. It was cited only in the dissent in Aratea. And while it was cited in Talaga, it did not become a controlling element in the decision. In fact, in Tagulino, the court, for the words of Justice Perlas Bernabé, even posited that intent to defraud is something which I quote, bears significance in a Section 78 petition, as it is enough that the person's declaration of a material representation in the COC be false. Your Honors, there is no other way to prove intent to deceive or mislead, which is a state of mind that is difficult to establish a priori in a summary Section 78 proceedings of the Comelec, except to base it on what has been laid down in jurisprudence. It is absent when there is no misrepresentation, as you ruled in Mitra, Fermin, and Pixon, or when there is misrepresentation but it is not material, or did not confuse the electorate, which was how ratiocinated in Salcedo, Dos Embastel, Villafuerte, and Hughes. Or when the misrepresentation is material, but is logically just an honest mistake that would lead to a disqualification if not corrected, which was the case in Romualdez Marcos. On the other hand, it is presumed to be present when there is material misrepresentation seen in the withholding of material information, which was your ruling in Obduracion and Caballero. It is a fact, Your Honors, that petitioner made a false representation on her residence by withholding the fact that she had no permanent resident status in the country from May 24, 2005 until July 2006. In addition, Your Honors, the claim by petitioner of having no intention to deceive or mislead can only be believable if we imagine her as a clueless, uneducated person, unfamiliar with concepts and processes and civics and politics. Your Honors, she is a political studies graduate of a respectable academic institution abroad. It is unbelievable for her not to have the knowledge of the fact that from May 24, 2005 until July 2006, that she was a non-resident alien, an American national on a temporary visitor status in the Philippines as a balikbayan. Petitioner tries so hard to turn this case into a quo warranto proceeding. In her insistence that it has no intent to deceive or mislead, to neuter Section 78 to allow her to run, despite the falsity of her representation about her residence. She is also urging you to allow the ballot to cure her legal and constitutional handicap, which would resurrect the political doctrine which you, through no less than the words of the Honorable Chief Justice herself, have already buried in a killing, for it runs counter to the very core of a constitutional democracy such as ours. Your Honors, petitioner is demanding that the grant her special treatment. This is attacking the rule of law and amounts to no less than an attempt to mount a coup against the Constitution. Your Honors, Justice will not be served by favoring the ambition of one over the interest of the many. In the face of the certainty of ambition and the uncertainty of politics, it is the steady and fair hand of the law that will ensure justice. Justice will be compromised, and the social contract will be breached if we suspend the rule of law and diminish the Constitution to benefit the political ambitions of one privileged foundling. Allowing her to run, despite committing material misrepresentation, will not benefit all foundlings among us as a marginalized class, since the remedy for them is in Congress for remedial legislation or in a constitutional convention to redraft the terms of the social contract that binds the Republic. Your Honors, the petitioner made a material misrepresentation and her COC with intent to deceive or mislead. The Comelec did not commit grave abuse of discretion in cancelling her COC, for it simply defended the Constitution from attack. Therefore, it is for these reasons that I humbly beseech you to please dismiss the petition.
Thank you, Dr. Contreras. May we now request the Solicitor General to please approach the podium for his 20-minute oral presentation.
Your Honors, good afternoon and may it please the Court. I speak as tribute of the people, consistent with the Honorable Court's advisory in these cases. Given the limited time allotted in this presentation, I shall focus on the two crucial issues in these cases. Number one, the political status of foundlings under the Constitution, and number two, the meaning of residence. On foundlings. Foundlings are natural-born citizens under all our constitutions. The 1934 Convention specifically tackled the status of foundlings, or children with unknown parents. The proposal of Delegate Raffles was to specifically recognize foundlings as Filipinos. The counter-proposal was to simply assume that they are Filipino citizens. Delegate Montinola saw no need to amend because, in his view, under domestic law, a foundling is the son of a Filipino. Delegate Rojas also saw no need for a proposal because cases involving foundlings are few and far between, and in his view, under international law, foundlings are citizens of the nation in which they are found. We all know that the Raffles proposal was rejected, but note that what was declined was the proposal for a textual and explicit recognition of foundlings as Filipinos. And so, the way to explain the constitutional silence is by saying that it was the view of Montinola and Rojas which prevailed, that there is no more need to expressly declare foundlings as Filipinos. Obviously, it doesn't matter whether Montinola's or Rojas' views were legally correct. Framers of a constitution can constitutionalize rules based on assumptions that are imperfect or even wrong. They can even overturn existing rules. This is basic. What matters here is that Montinola and Rojas were able to convince their colleagues in the convention that there is no more need to expressly declare foundlings as Filipinos because they are already impliedly so recognized. In other words, the constitutional silence is fully explained in terms of linguistic efficiency and the avoidance of redundancy. The policy is clear. It is to recognize foundlings as a class, as Filipinos under Article 4, Section 1, Paragraph 3 of the 1935 Constitution. This inclusive policy is carried over into the 1973 and 1987 Constitution. It is appropriate to invoke a famous scholar as he was paraphrased by Chief Justice Fernando. The Constitution is not silently silent, it is silently vocal. Even without assistance from the records of the 1935 Constitution, foundlings would still be natural-born Filipino citizens. The fundamental practical basis for recognizing foundlings as Filipinos is not to give them special privilege, advantage, or status, but to acknowledge their right against the total loss of fundamental political rights for reasons not attributable to them. Foundlings are natural-born citizens as a matter of right because it is safe to assume that their parents are Filipinos in the same way that it is safe to assume that those with birth certificates indicating Filipino parentage are also natural-born Filipinos, even if those papers are only prima facie proof of Filipino affiliation. To conclude, to exclude foundlings from exercising fundamental political rights and make them legally invisible would be baseless, unjust, discriminatory, contrary to common sense, and the wrong way to interpret the Constitution. First, it is baseless because there is no evidence at all that the framers of the 1935, 1973, and the 1987 Constitution intended to deny foundlings their status as Filipinos. We cannot interpret the Constitution's silence as indicating a discriminatory animus against an entire class of persons in the face of the clearly discernible intent in the records to recognize them as Filipinos. Let me reiterate, the debate in the records was whether foundlings should be recognized as Filipinos expressly or impliedly, not whether they should even be recognized as Filipinos. To deny foundlings the most fundamental of their political rights, because their class is not expressly mentioned in the Constitution, is a simplistic and lackadaisical way to interpret the Constitution. The common error is to read the text of the Constitution without reference to history, structure, or social context. We should not commit that error here. Second, it is contrary to common sense because foreigners do not come to the Philippines so they can get pregnant and leave their newborn babies behind. We do not face a situation where the probability is such that every foundling would have a 50% chance of being a Filipino and a 50% chance of being a foreigner. We need to frame our questions properly. What are the chances that the parents of anyone born in the Philippines would be foreigners? Almost zero. What are the chances that the parents of anyone born in the Philippines would be Filipinos? 99.9%. According to the Philippine Statistics Authority, from 2010 to 2014, on a yearly average, there were 1,766,046 children born in the Philippines to Filipino parents, as opposed to 1,301 children born in the Philippines of Filipino parents. Thus, for that sample period, the ratio of non-Filipino children to natural-born Filipino children is 1:1,357. This means that the statistical probability that any child born in the Philippines would be a natural-born Filipino is 99.93%. From 1965 to 1975, the total number of foreigners born in the Philippines is 15,986, while the total number of Filipinos born in the Philippines is 10,558,278. For this period, the ratio of non-Filipino children to Filipino children is 1:661. This means that the statistical probability that any child born in the Philippines on that decade would be a natural-born Filipino is 99.83%. We can invite statisticians and social anthropologists to crunch the numbers for us, but I am confident that the statistical probability that a child born in the Philippines would be a natural-born Filipino will not be affected by whether or not the parents are known. If at all, the likelihood that a family would have a Filipino parent might even be higher than 99.9%. Filipinos abandon their children out of poverty or perhaps shame. We do not imagine foreigners abandoning their children here in the Philippines, thinking those infants would have better economic opportunities, and believing that this country is a tropical paradise suitable for raising abandoned children. I certainly doubt whether a foreign couple has ever considered their child excess baggage that is best left behind. To deny full Filipino citizenship to all families and render them stateless just because there may be a theoretical chance that one among the thousands of these families might be the child of not just one, but two foreigners is downright discriminatory, irrational, and unjust. It just doesn't make any sense. Given the statistical certainty, 99.9%, that any child born in the Philippines would be a natural-born citizen, a decision denying families such status is effectively a denial of their birthright. There is no reason why this honorable court should use an improbable hypothetical to sacrifice the fundamental political rights on an entire class of human beings. Your Honors, constitutional interpretation and the use of common sense are not separate disciplines. Third, those who drafted our Constitution worked to create a just and humane society. They were reasonable patriots, and it would be unfair to impute upon them any discriminatory intent against foundlings. Given the great implications of the argument that foundlings are not natural-born Filipinos, I strongly advise the members of the Honorable Court not only to search your feelings, but more important, to search the records of the 1935, 1973, and the 1987 Constitution for an express intention to deny foundlings the status of Filipinos. The burden is on those who wish to use the Constitution to discriminate against foundlings to show that the Constitution really intended to take this path to the dark side and inflict this across-the-board marginalization. As I have stated in my comment before the Senate Electoral Tribunal, in the language of constitutional law, foundlings are a discrete and insular minority. Because of their marginalized status, they are entitled to special protection, and any government action that burdens the exercise of their rights must survive strict scrutiny. The policy must be done for compelling reasons and be narrowly tailored. We might want to ask, where is the sense of priority and fairness in the genocide of the political rights of thousands of foundlings just because we are so obsessive-compulsive about purity of blood? I therefore invoke the rights of foundlings to equal protection in general and the right to, quote, equal access to opportunities for public service, unquote, under Article 2, Section 26 of the Constitution in particular. For the avoidance of doubt, by referring to foundlings as members of a discrete and insular minority, I am summoning the entire corpus of anti-discrimination jurisprudence on their side. Your Honors, Our constitutional order will not disintegrate if we address the systemic injustice suffered by thousands of foundlings by recognizing their rights to full citizenship and in the process letting one or two muggles get away. Fourth, considering my position on the constitutional status of foundlings as natural-born citizens of the Republic, I see no need to dwell on the effect of international instruments in their political status in the Philippines. But allow me to state two important matters of context. Number one, if we are going to use international law at all, we should use it for progressive ends, consistent with our Constitution's grand ideals, not for discriminatory purposes. And number two, the total effect of those documents is to signify to this honorable court that those treaties and conventions were drafted because the world community is concerned that the situation of foundlings renders them legally invisible. It would be tragically ironic if this honorable court ended up using the international instruments which seek to protect and uplift foundlings as the very tool to deny them political status or to accord them second-class citizenship. On residence. The question of residence equally requires us to go back to first principles. Residence is a general requirement for elective public offices because of the theory that residents of a certain jurisdiction would have the presumed familiarity with the place in which they seek to serve. As a general proposition, the lengthier the residence, the greater the presumed familiarity. The Constitution's requirement of 1 year for Congress, 2 years for the Senate, and 10 years for the President reflects this basic concept. The numbers are, of course, arbitrary. Real familiarity of the candidate, the more important aspect of governance, is tested by other means: debates, interviews, speeches, platform of government. These are matters concerned by the people at the level of the ballot, not by the Comelec at the level of the certificate of candidacy. This is not to say that residence qualifications mean nothing at all. They are, like citizenship, formal qualifications and cannot be dispensed with. But we need to apply them consistent with their purpose, which is simply to ensure a minimal sense of familiarity with the locale. This rationale is reflected in the way the Supreme Court has constructed its jurisprudence around this particular requirement. To comply with the rules of residence, a candidate needs only two things. Number one, an intention to reside, a subjective factor, and number two, a factual anchor, an objective factor that confirms such an intention. There is no documentary requirement for proving either intention to reside or the fact of residence. What is only needed is that such intention to reside be validated by a factual anchor through substantial evidence. The case of petitioner is a good model for applying these concepts. Has petitioner satisfied the 10-year residence requirement of the Constitution? The answer is yes. In December of 2004, petitioner's father died, which event she claims was crucial in her decision to return to the Philippines for good. She was in the Philippines from December of 2004 to February of 2005, then went back to the United States. The tipping point seems to have been 2005, when she returned to the Philippines along with her 3 children, who in the meantime were uprooted from their schools in the United States and transferred to schools in Manila. They lived with their mother for a while,
then transferred to a condominium with her new family home was being built. The narrative of our private and public life has since then been centered on the Philippines, save for a few visits to the United States. Based on these facts, the claim that she has been a resident of the Philippines for at least 10 years is a valid claim. In the first place, it is a fact that she has been in the Philippines since 2005. In the second place, her life in the Philippines from 2005 to today is a coherent narrative of a permanent return to one's roots and a permanent abandonment of one's second home. Quite apart from the fact that we should consider a person's assertion as the sovereign manifestation for will or animals, is the validating fact that when petitioner came back in 2005, she had her children with her who had just been removed from their American schools and transferred to schools in Manila. For most Filipinos, where your children are is where your home is. In other words, petitioner's pivot to the Philippines is definitely marked by, number one, her presence here, and number two, her children's return and subsequent enrollment. These facts are more telling than an alien certificate of registration or an immigrant status from the Bureau of Immigration. People's lives revolve around experiences and relationships, not papers. It is of course true that it was not until 2006 that she reacquired her Philippine citizenship. This fact is also totally irrelevant to her residence. Residence and citizenship, this honorable court has repeatedly declared, are two separate formal qualifications with independent rationale. They are separate gears and levers of a single machine. Citizenship establishes formal political allegiance. Residence indicates presumed familiarity. Couched in logical terms, a citizen need not be a resident, as is the case with many dual citizens, and a resident need not be a citizen. Obviously, one does not need citizenship to acquire familiarity with the politics and economics of a jurisdiction. It follows that one's residence can precede the acquisition or reacquisition of citizenship. These rules should apply with greater force to returning Filipinos because of their prior knowledge of the conditions of the motherland. We embrace returning Filipinos with open arms. They are our friends, relatives, and neighbors whose experience abroad have widened their views of the world. We do not see them as traitors. This view is also a self-reflection. We are the friends, relatives, and neighbors who patiently wait outside the Nahia, ready with our warm embrace. We are not jingoists lurking in the darkness with moral judgment. There is also some debate about the effect of petitioner's declaration in her certificate of candidacy for the Senate, pegging her residence at some time in 2006, not 2005. The Comelec considered such declaration conclusive and binding for purposes of determining the length of petitioner's residence for the presidency. With all due respect to my colleagues at the Comelec, this is a mistake. The confusion can be resolved with a simple example. A natural-born Filipino who has been a resident of the Philippines from birth decides to run for the Senate and declares his length of residence as only 5 years, which was after he returned to the Philippines after finishing his master's degree abroad. Can he be disqualified from running for the Senate by the Comelec pursuant to Section 78 of the Election Code? No, because the residence qualification for the Senate is only 2 years, and the candidate could have placed an even longer period of residence if he understood
what residence means under our election laws. Following the language of Section 78, the declaration is false, but not materially so. It is therefore a valid declaration. Suppose the same candidate decides to run for the presidency 3 years later. Is he conclusively bound by the certificate of candidacy for the Senate, in which case he only can add 3 more years to his prior declaration of 5 years, and thus be disqualified for the presidency, which requires a 10-year residence? The answer is no, because in the first place, she has the right to declare a longer period of residence from birth. The situation of Senator Grace Poe fits this basic model. She could have pegged her residence at 2005 in her certificate of candidacy for the Senate, but did not. Nothing prevents her from making that declaration now in her certificate of candidacy for president, because both declarations would be valid under Section 78 of the Election Code. This ends my presentation, which I sincerely hope can be of assistance to this honorable court. Thank you.
Thank you, Mr. Solicitor General. I will now request Commissioner Lee to approach the podium for the continuance of the interpellations by Justice Francis Mendoza. Justice Mendoza, please.
I yield to Justice Velasco.
Good afternoon.
Good afternoon, Commissioner Lim, and I'll be very brief. And rather than questions, I will have few suggestions on the matters that you cover in your memorandum. On they are limited to equal protection. Please cover in your memorandum. In my view, you have the Comelec has an equal protection problem. The underlying issue here is citizenship. And the comparison will be between a foundling and a non-foundling citizen, as in, remember the case of Paa versus Chan. So, we'll compare a foundling with Chan. First item to cover in your memo. In my view, the statements of the Comelec and Bank that the foundling cannot definitively show that she is natural born, because it is certain that she cannot show bloodline, and in fact her bloodline is indemonstrable, to use your words. Violates the equal protection of the foundling, because in the case of all others, for example Chan, all types of relevant evidence are admissible. Do you follow that question?
Yes, Your Honor. May I respond?
Can I just finish? Second item, I think you have violated also the equal protection rights of the foundling, because by saying that it is in that bloodline is indemonstrable, you have created a higher burden than the burden allowed to Chan or to all others. In the case of Chan, for example, it's only substantial evidence. When the NBank says it is indemonstrable, effectively you're saying you are having a hurdle higher than substantial, even higher than preponderant, and even higher than beyond reasonable doubt. To my mind, that's the second violation of the equal protection of the foundling. Now, in my view, the foundling is a fundamental value, a fundamental right to a nationality, and I agree with the claimant of the people she belongs to a discrete and insular minority. In equal protection terms, the test now, the Tumas hurdle is what we call strict scrutiny. Under strict scrutiny analysis, the government has to meet a compelling case has already said they are on the side of the founding. So the government has stated, in effect, there is no compelling state interest. So state for me in your memo, what is the compelling state interest to make a discrimination against the founding? Now, you just heard the Solicitor General as Tribune of the People. The Tribune of the People, again, is taking the side of the founding. So, the Comelec now has to have the burden of crafting or articulating what is the compelling state interest. My final question is, I think at the last time you embraced the view that picking up from some opinions in the set decisions, you embrace the view that the founding is naturalized and naturalized citizen who, if he or she finds DNA evidence, can become natural born. You embrace that view, right?
That is not the view of the Commission. We did not discuss that in the Assent resolution. But in the course of the discussion, Your Honor, the sample representation expressed that view. With your kind indulgence, Your Honor, let me allow to address.
Can I just finish? So you are expressing that view. You are embracing that view.
Yes, Your Honor.
Can I just put my question and you can answer? Please cover again in your memorandum your view, which you echo a view made in the set decision. I say that view still suffers from the same constitutional vice of a violation of equal protection, because that view still brings a burden producing DNA evidence which is not required of the ordinary claimant to a citizenship. Now, the word used, one of the words used in equal protection parlance is that discrimination is odious. Odious. I suggest to you that that type of analysis of yours now is even more odious. It is cruel, counsel, because effectively it is a conclusive presumption masquerading as a benign protection of a founding. So I find it not only odious but cruel. You are tangling a vain hope to a founding. Now, number one, she's discriminated. She's merely naturalized, but you are saying, well, in any event, if you find out who your parents are, then I am dangling to you, proved by DNA evidence. I think more than being odious, that type of discrimination is cruel. So, could you please cover that in your memorandum if you want to discuss that?
Yes, Your Honor. With your kind indulgence, may I please respond, Your Honor, with the permission of the Honorable Chief Justice. There are certain concerns I'd like to raise. First of all, Your Honor, I respectfully submit and insist that there is no violation of equal protection here, because we are speaking here in this case of a particular petitioner who happens to be a foundling, and that is just half of the story. By foundling and by definition, she is one with parents unknown. Therefore, as of the time we speak, parentage is indemonstrable. It is within that context that the word indemonstrable was used in our resolutions. Secondly, Your Honor, we refer here not to an ordinary founding, but to a founding who renounced the Philippines as her home country. A foundling, with all due respect to the petitioner, who took an oath of allegiance to the United States, and by that act completely severed, or rather, were it not for the benevolence of the Philippine state through Republic Act 9225, she severed completely and irrevocably her ties to her native country. And in that oath of allegiance to the U.S. government, she swore under oath to bear arms for the United States, while at the same time renouncing her native country. Had a one-day war broken out between the Philippines and the United States while she was a U.S. citizen, she would have taken up arms on the side of the United States and against her former home country, the Philippines. This is a consensus among many lawyers. I can mention Attorney Art Alapriso is very strong on this kind of sentiment. So there is no unequal protection, there is no violation of equal protection, Your Honor, because there is reasonable basis to classify the petitioner as a foundling vis-a-vis the 3,999 other foundlings who never renounced their country and who are not running for President of the Philippines. I respectfully submit that a closer and more careful scrutiny be given to the petitioner who is incidentally a foundling because of certain events that happened in her life. We do not condemn her for having taken an oath of allegiance to the U.S., but action always implies consequences. There is a disputable presumption in law that a person is deemed responsible for all the natural consequences of his voluntary act. You renounce Philippine citizenship, you take an oath of allegiance to the U.S., your ties to your country are completely severed. Here comes the Philippine state, benevolent as it is, through Republic Act 9225, allowing you to repatriate. But the repatriate does not reacquire natural born status, Your Honor, with due respect to the holding of this court in Benson III versus Exlect. In the words of Justice Brion, his number one misgiving for not abandoning the doctrine in Exlect versus Benson is the possibility of perpetuating and maintaining an unconstitutionality. Because in that case, it was ruled that what is reacquired is natural born status. Because of the holding of Justice Mendoza, reiterated by Justice Capunan, that when you reacquire under the law your citizenship, you reacquire your inherent, inborn, and intuit right to citizenship. You are always natural born deep inside you. Even if you are already an American citizen, America and the person concerned have turned their back on the Philippines. But Philippine law still insists on claiming him as one of his own. And moreover, Your Honor, if I may just emphasize this point, because I am in effect respectfully reacting to the position of the Tribune of the People, since the petitioner is not only a foundling, but was a foundling or is a foundling who renounced Philippine citizenship and subsequently reacquired it, if the court is so minded to rule that what was reacquired was simply Philippine citizenship, the naturalized time, since there are only two classes, since RA 9225 is merely an expeditious mode of reacquiring citizenship, if the court is so minded in making that ruling, then the petitioner would still be not natural born. Not only because she is a foundling and therefore not natural born under Section 2 of Article 4 of the Constitution, but equally important because she renounced Philippine citizenship, and assuming she was natural born, even on that charitable assumption, what she would have reacquired was merely naturalized status. That is our submission, Your Honor, and we feel very strongly, although we do not blame the good justice, we respect your views, Your Honor, but we have thoroughly discussed this to the best of our abilities, and we never reached the conclusion that we would be violating equal protection here, Your Honor. I'm sorry for the lengthy explanation, Your Honor.
That's all. And again, I thank the council, and it is my privilege to have this conversation with you. Thank you, council.
Thank you, Your Honor.
Thank you. Council, good afternoon.
Good afternoon, Your Honor.
I would just like to dwell into some procedural matters. The second division of the Comelec, your division decided against petitioner Poe. Is that correct?
Yes, Your Honor.
And then petitioner Poe or Llamanzares filed a motion for reconsideration, right?
Yes, Your Honor.
And what was the vote of the en banc on the motion for reconsideration of Llamanzares, Senator Poe?
4-1, Your Honor.
4-1.
For appeal, 2 dissent, 1 abstain.
One abstain, okay. Now, if there was only a vote of 3 members on the motion for reconsideration, what is the rule of the Comelec?
Under Section 6, Rule 18 of the Comelec Rules of Procedure of 1993, Your Honor, if the en banc is divided in its opinion or a majority vote cannot be had, because under the Constitution it requires majority of the members of the Commission, so that means 4 votes. If it is divided and a majority vote cannot be had, there shall be a rehearing.
What happens
And
after
if upon rehearing there is still no majority vote or decision, then the action, if originally commenced with the Commission, shall be dismissed.
Does it mean that the petition to declare, to deny due course or cancel the COC will be dismissed?
Yes, Your Honor. Because it was an action originally filed with the Commission, unlike in appeal cases, if that would be the situation, the judgment under appeal from the MTC or the RTC, as the case may be, will stand appeal. And in all other interlocutory matters, it shall be denied.
So in that situation where the movement gets only 3 votes for the grant of the motion for reconsideration, then the actual result will be that she will be favored by the non-attainment of the majority vote of 4. Is that correct?
Yes, Your Honor. As required, not just by our rules, but by the Constitution, it prescribes 4 votes, Your Honor, majority of the members of each commission. So, referring to CLEA and Comelec, Your Honor.
Well, I'm just curious about the effect of your rule because the movement is the one that is supposed to get the majority vote of 4, and then in the event that she doesn't get the required majority vote of 4, in effect, she is favored by the non-attainment of the majority of 4 votes. Isn't that correct?
By express provision of the rules and of the Constitution, Your Honor, because the Constitution prescribes that the Commission may sit en banc and in divisions, in 2 divisions, and in the case of, in the exercise of the Comelec's adjudicatory or quasi-judicial powers, the en banc has to have 4 votes, although 4 would constitute a quorum. If the entire quorum in a situation where there would be only 4 members, like the situation when Chairman Brillantes, Tagle, and Yusuf retired. There were just the four of us. It was required that the commission be unanimous, Your Honor. The prescribed voting.
Okay, so this is just a rule of the commission. And of course, the rule of the commission should comply with the constitutional provision of the, or rather the provision of the constitution, right?
Yes,
Should
Your
be
Honor.
compliant with the constitutional provision.
Yes, Your Honor.
Okay, so I'm just concerned about the effect of that kind of rule because to my mind, even if the movement does not get the majority vote of 4, in reality, he is the one benefited by the non-attainment of the majority of 4 votes. Anyway, do you agree with the ruling of the Supreme Court in Mitra versus Comelec?
In all candor, Your Honor wrote a very persuasive dissent. We recognize the binding effect upon all of us of the majority decision. We admit we respect and bow down before the majority decision. But I would like to observe, Your Honor, that if I may, Your Honor wrote a very persuasive dissenting opinion.
Okay, but so you agree that the transfer of residence can be accomplished not through a single move but through an incremental process.
That was one of the rules or doctrines laid down by the court to Justice Brion in that case.
Okay.
And personally, it also makes sense, Your Honor, because residence or domicile is essentially a matter of intent. But as differentiated from the present case, there is no naturalization that severed the relationship between the candidate and his or her home country. In the case of Mr. Mitra, it was only by reason of the fact that Puerto Princesa had become a highly urbanized city that he found it necessary to transfer or move out of Puerto Princesa, in this case a Borlan municipality, to qualify him for the governorship. But the court there held that transfer of residence need not be in one final bold stroke. It can be incremental. So that is, as I understand it, that was the ruling of the court, Your Honor. We accept the ruling, Your Honor.
How can you compare the facts in relation to acquisition of residence in the Mitra case and as compared to the circumstances of the acquisition of residence by Senator Poe? How can you compare the facts in the two cases?
The biggest difference, Your Honor, is in the fact that Senator Poe renounced Philippine citizenship and acquired American citizenship, and consequently, on the strength of jurisprudence, she lost both Philippine citizenship and Philippine domicile. The law on dual citizenship came to her rescue, so to speak, and the law was enacted in 2003. She became an American citizen in 2001, so she was allowed to reacquire Philippine citizenship. But reacquisition of Philippine citizenship, which applies to those who lost Philippine citizenship before 2003, does not automatically impact on residence. Residence has to be separately re-established. And according again to jurisprudence, and there are many, it is re-established upon concurrence of certain factual evidences of re-establishment as shown by overtops, namely bodily presence, animus manendi, intention to remain, and animals non-libertandi. In the case of Mrs. Llamanzares, we submit, and it was the finding of the Commission, Your Honor, that while she had bodily presence in the country, while ostensibly there might have been already an intention to stay, although that is strongly negated by a visa-free balikbayan visitor stay of 1 year, the animus non-libertandi was completely absent because she decided to retain her U.S. citizenship. She continued using her U.S. passports. She never applied for permanent resident status and thereby was ambivalent about residency in the Philippines. In your provincia, Your Honor, also in Sabili, which was also a dissenting opinion, you also stated, Your Honor, that the animus to establish residence or establish residence must not be doubtful. Sad to say, in the case of the petitioner, the totality of the acts and the totality of the overt acts show an ambivalent attitude towards Philippine residency. She allowed her balikbayan stay to lapse in May 2006, and barely a month later, she decided to repatriate. That is the story of her life, if we may put it that way, and this impacts strongly on the intent to re-establish residence. Just to complete, Your Honor, now going to Mr. Mitra, he was in the same province, Your Honor, same area, Palawan, and he was formerly key-term congressman already of Palawan. So he knew Palawan like the palm of his hand. He just sought a Bordan to qualify him for the governorship. And while he made incremental moves, his animus to establish it in Palawan was so different from Reyes, another Palawenyo, who tried to establish residence in Aborlan, but this court said that that cannot be because your residence is just a beach house, which by its nature is really temporary. So, to sum it up, Your Honor, Congressman Mitra never renounced citizenship, never lost Philippine residence. It was just a question of the 1 year residency requirement, whether he had effectively left to Princesa and whether we had really acquired a new one in Aborlan. And Justice Bayon explained to us that this can be incremental. Although Your Honor took a strong exception to that because essentially the focus there was the lessening of the feed mill, whether it would qualify as a residence. And in the dissenting opinion of Your Honor, you highlighted the fact that it did not even have a kitchen and a comfort room. So how could it be used as a residence? So the difference Mitra does not apply here, Your Honor, if I may say so.
Thank you, Counsel. So, can you just explain that very well in your memorandum? Thank you.
Yes, Your Honor.
Justice Carpio.
Counsel,
Yes, Your Honor.
Article 3, you mentioned this before, Article 3 of the Civil Code,
Yes, Your Honor.
ignorance of the law excuses no one, non-compliance, they're really correct.
Yes, Your Honor.
And that is basically saying that everyone is conclusively presumed to know the law, correct?
Yes, Your Honor. We believe in that, Your Honor.
So, if let's say an alien comes here today, buys land, and the land, let's say, is annulled because he cannot buy land, he's an alien, can the alien raise the defense that I did not know about this
No, Your Honor.
So everybody, because even an alien in the Philippines is conclusively presumed to know the Constitution, correct?
Yes, Your Honor.
And if you are a Filipino in the Philippines, you are conclusively presumed to know the Constitution, correct?
Yes, Your Honor.
Let's say there is one person in one of the islands in southern Mindanao where the revised penal code never reached it. And this person is charged with murder. And he raises the defense, but I never read the revised penal code. I didn't know that killing would constitute murder. Can he raise the defense that he does not know the law? Actually, he had no actual notice of the law.
That cannot be, Your Honor.
Because there is a conclusive presumption that you know the law, correct?
Yes, Your Honor.
Whether you actually read the law or not, correct?
The stability and the life of our institutions depend on that, Your Honor.
Yes. In other words, our entire legal system is founded on the rule that every citizen and every person found in the Philippines is presumed to know the laws, including the Constitution, correct?
Yes, Your Honor.
Even if they don't actually know it, correct?
Yes, Your Honor.
Even if he doesn't know how to read and write, correct?
Yes, Your Honor.
So, and in fact, in our legal system, in our laws, we have several laws saying putting conclusive legal presumptions, correct?
Yes, Your Honor.
You have in the energy law, in the I have it here, so insurance code, public land act, corporation law, human rights victims authorization and recognition act, anti-child pornography, so and so. So there are so many laws establishing conclusive presumptions, which means that even if you don't know it, you are conclusively presumed to have known it, correct?
Yes, Your Honor.
You cannot raise the defense that that is against the due process clause of the Constitution.
Definitely not, Your Honor. Even in the law on common carriers, we have such presumption already.
Okay. Now, you mentioned several times my dissenting opinion in the Senate. Did I ever say in my dissent that the only evidence that could have been presented and admissible is DNA evidence?
No, that's not my reading, Your Honor.
Yes. In fact, I stated, and I will quote, one of the evidence that she could have presented before the tribunal is DNA evidence. End of quote. Yes, you say one of the evidence, that these are many evidence, and this is one of them, correct?
That's correct, Your Honor.
Okay. So, you also quoted the oath of allegiance of a person who is naturalized as an American. And it says, I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign state of which I have been a subject or citizen, correct?
That is in the oath of allegiance.
Yes. And in other words, petitioner took an oath when she became a naturalized American that she absolutely and entirely renounced and abjured all allegiance and fidelity to the Philippines.
That was a requirement for American citizenship, Your Honor.
And when she came here in 2004, 2005, she was bound by this oath, correct?
Yes, Your Honor.
And she was unburdened by this oath, released from this oath, only when she renounced it in July 2006, correct?
Yes, Your Honor.
So before the renunciation, she was bound by this oath. She could take up arms against the Philippines, correct? Because it's in the oath.
Definitely, Your Honor.
So she had no allegiance, no fidelity whatsoever to the Philippines before July of 2006.
That is correct, Your Honor.
At 2010, when she renounced American citizenship, she became dual in 2006. So she carried this oath until renunciation in 2010.
July 20, Your Honor.
2010, when she became chair of the FPRCB, she had to renounce because as a public officer, you have to renounce foreign citizenship, correct?
Yes, Your Honor.
So she had this duty, obligation to the United States up to whether she stayed here or not, she was bound by this oath, correct?
Definitely, Your Honor.
Okay. Let's go to the oath of application of petitioner when she acquired for dual citizenship. That's Exhibit 20. And it says here, I, Mary Grace Poe-Llamanzares, of legal age, married, an American citizen, an American resident. She is an American resident of address. And then it says here, I am a former natural-born Philippine citizen, born on September 3, 1968 at Iloilo City. 2. Born to Ronald Allen Kelly Poe, a Filipino citizen, and Susa Sonora Poe, a Filipino citizen. Born to. What do you understand by born to?
We took that into account, and that was one of the principal reasons for our ruling. Born to means biologically born to. That the parents mentioned are or were biological parents.
So, when you say you are born to so and so, that is your father. Biological.
Yes, Your Honor.
Now, how do you characterize this statement? Is this incorrect, false, or correct?
It is a material representation that is false and which by and of itself, per Tagulino versus Exwell, constitutes material misrepresentation. That was reiterated in the COC, not only for 2013, but more importantly, 2016 COC.
So, in other words, that statement that she is born to Ronaldo is false.
False, Your Honor.
Now, this is a pre-printed form by the Bureau of Immigration, correct?
Yes, Your Honor.
So, she filled it out, and the pre-printed form says that born to. You have to fill up those forms. So, the immigration assumes that you are a former natural-born citizen, so you are born to a Filipino, correct?
That is correct, because the law itself, Your Honor, RA 9225, is intended to cover natural-born citizens. So,
You must be a natural-born citizen. So, it is very material that you have to state the name of your father because then you will know whether he is a Filipino or not.
yes, Your Honor.
Because how do you know you are a Filipino, former natural-born, except by saying who is your father, and your father is a Filipino, then you are natural-born, correct? So it's very material that you have to state correctly who is your father, biological father, correct?
Yes, Your Honor.
Born to. So this phrase, the word born to, was specifically chosen by the Bureau of Immigration, correct?
Yes, Your Honor.
Because you must state your biological father. Because that's the requirement of the law. You can only apply for dual if you are a former natural born. Naturalized are not allowed, correct?
Yes, Your Honor.
So, if you put something, in the blank born to, you mention a name that is not your biological father, that's falsity, and it's very material, correct?
Yes, that's material misrepresentation, Your Honor.
So it's very material that you state your biological father. And if you state a name that is not your biological father, that's a material falsity.
Yes, Your Honor, especially that it led or misled the office concerned into granting the petition.
So if, for example, she did not say born to, she will say adopted. She crossed the word born to. She put it adopted by Ronald Allen Poe and Jesusa Sonora Poe. Would the application have been granted?
I doubt it very much, Your Honor. Although the statement or representation in that situation would be factually true, that it may have been disapproved.
Yes, because we cannot grant dual citizenship to somebody who is not naturally born, correct?
Yes, it may be result, Your Honor.
Because it's clearly a false statement. And it's very material because even the Bureau of Immigration specifically wrote born to, that means biological father, has to be stated there.
Yes, Your Honor, because the law is only for foreigner natural born Filipinos, Your Honor.
Okay, that is all, counsel.
Thank you, Your Honor.
Justice Castillo and then Justice Perez.
Counsel, just a few follow-up questions to the questions of Justice Cathy on a renunciation of the petitioner. When did President Aquino appoint Petitioner Grespo as chair of the MTRC?
October 21, 2010.
Wasn't it October 6, 2010? But October 21, 2010 was the day she assumed office.
She took the oath.
Yes.
Yeah.
And before that, she had to execute an affidavit of renunciation of her American citizenship, wasn't it?
On October 20,
The day before.
2010.
What do you make of that? I mean, would you say that that was something voluntary? Or what? The renunciation? Don't you think that it would seem that it was an unwavering, it was a renunciation, not voluntary? She had to do it simply because it was a requirement of the assumption of being chairman, to assume, to become chairman of the office.
Unfortunately, that is the case, and that reminds this representation once again of McKilling versus Comelec, what the Chief Justice said there about citizenship not being a matter of convenience.
From October 6 until October 20, it's quite some time, no?
Yes, Your Honor.
And so it took her some time really to decide whether to remain an American.
Chairperson of MTRCB, Your Honor.
So you think that this renunciation on her part was really what she wanted?
We would leave that to the sound judgment of the court, but since I am standing here, Your Honor, I cannot avoid answering your question. It was purposely just to enable her to accept the appointment to a government post, Your Honor.
Thank you, Counsel.
Thank you, Your Honor.
There's one follow-up question. Because of the question of Justice Del Castillo. Now, under RA 9225, you have to renounce your American citizenship because that's required under the law. It's not a matter of convenience. It is a requirement under RA 9225. But if you want to hold a public office, you have to renounce your citizenship. That is not a matter of convenience.
That is correct, Your Honor, but when I use the word convenience, I was referring to the circumstances surrounding the renunciation.
But that is a requirement.
Yes, Your Honor. Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Principal question, can the dual citizenship of petitioner be collaterally attacked? Is that not a given fact in this case? That's never questioned. It is there in the records. The C is, or acquired dual citizenship. So we can be collaterally attacking these proceedings.
May I answer, Your Honor? The citizenship of the petitioner was not collaterally attacked. There is no collateral attack here, Your Honor, in these proceedings. There was simply a filing by her on October 15, 2015 of her COC for President in the 2016 elections, which invited the action from the private respondents. They filed petition to cancel COC invoking Section 78 of the OAC, and the Comelec, in the discharge of its mandate, merely inquired into the issue of whether or not a material representation was made in the COC, which under Section 74 of the law is false. That would not be collateral attack.
I consider that, I will not tell you that I consider that answer as satisfactory or directly answering my question. Let me go to my next question on another point, because I think we will go around in circles, because you'll be lecturing on a point which does not answer my direct question. Anyway, you can include that in your memorandum. The question is, in reading the petition of Council Contreras, there was a determined focus on the date July 2006, the reacquisition, so-called, of the Filipino citizenship under 1925, and on the citations of Coquilla, that reflect that there can be no other reference except to that date 2006. Such that, when Poe stated in her certificate of candidacy that she complied with the 10-year residency, putting in that box 10 years, 11 months, etc., it was false representation because from July 2006, the reference point of Mr. Contreras up to May of 2016 is less than 10 years. And then, reading the decision of the Comelec, there was, again, special focus on the date that petitioner Poe mentioned in her certificate of candidacy for the Senate, and that is November 2006, if I'm not mistaken. My question is, when Poe wrote 10 years and 11 months as her period of residency for purposes of the presidency, can we consider it a fact, or should she be considered as knowing the law, knowing everything about jurisprudence as much as Commissioner Artley knows the law?
Your Honor, please, Justice Carter earlier referred to the presumption about knowing the law. To answer your question, Your Honor, the petitioner is no ordinary person. She happens to be a senator, a political science graduate, academic background, and with a very well-trained staff of lawyers. We are just saying, Your Honor, that it was not simply an innocuous mistake. When she mentioned 6 years and 6 months in her 2012 COC, bringing her start of residence to November 2006. Now, if it is her intention to show that the statement in her current COC of 10 years and 11 months before May 9, 2016 is the correct statement, it is her burden to show that what she stated in her 2012 COC is the one that is false. Because presently, Your Honor, we can well indulge in the presumption, and we are now talking here of presumption, Section 6, I think, of Article of Rule 130, admission by a party. That is the best, that document is the best evidence that would shed light on the fact of the issue.
I'll get to that point. Go back to my question a while ago, and we charge petitioner Poe with as much knowledge of the law as Commissioner Art. And you said you relied on that dictum that everyone is presumed to know the law. Can the law on this matter, quote-unquote, established fact, cannot Poe rely as much on the things that the Tribune of the People has just stated a while ago?
Your Honor, Honor, please to answer your question. She knew what she filled up there. That is our finding, the finding of the commission. When she stated she was not under duty to put 6 years because the residency qualification was just 2 years. And she just wanted to qualify, maybe 3 years might have sufficed. But she stated the correct period of her residency.
My question is, once you wrote May of 2005, what? In the certificate of candidacy for the Senate, has the petitioner in the petition for cancellation made an allegation and did the commission make any finding that on the date that she filed her certificate of candidacy already contemplated of being a candidate for president from 2016? And was that, if that is the contemplation of law, was that idea already made known to the entire public, to the entire Philippine electorate, that she will be running for president in 2016?
Your Honor, there are only 2 COCs in question. The COC filed in October 2012 for the May 13, 2013 senatorial election, where she stated 6 years and 6 months. She did not mention any particular year or month as a starting point of residence. She only answered,
cannot both dates be correct?
it cannot, Your Honor, because simple arithmetical computation. In the 2012 COC, the question was period of residency in the Philippines up to May 13, 2013. Answer, 6 years and 6 months.
For who possesses of the senatorial candidacy?
If you may allow me to finish, Your Honor. She later remonstrated that the form was confusing. She said, I thought that it would be up to the date of filing in October 2012. That was the date and month she filed her COC. So if you apply 6 years and 6 months, go back 6 years and 6 months, reckon from October 2012, that would be April 2006.
Just answer, because it's a simple question. Attorney Lamparo is here. Was there any allegation? And the petition to cancel the certificate of candidacy that one already contemplated about running for presidency from 2013 but 2016. And that such idea is already made known to everyone that she will be running for president. Because I think that without those facts, she can make mention of 2 dates for each particular purpose. How can, you can discuss that in your memorandum because that convinced me that fate that she mentioned in her certificate of candidacy for a senator. Second, can Poe be charged with the knowledge that in filling up the COC, she can rely also if the petitioner in that motion or petition for cancellation can rely on Kenya, that she can also rely on other jurisprudence saying that it is the fact of residence which is the decisive factor in determining whether or not an individual has satisfied the residential requirement. Because Kenya says there is no other date of reckoning except the renunciation date. But there is another string of jurisprudence which says, no, it is the fact of residence. Of course, that is the present debate. But cannot Poe at that time be entitled to rely on the other jurisprudence?
May I answer, Your Honor? the intention of Poe, or of Senator Poe, to run for president when she filed her COC for senator in October 2012 is a completely immaterial consideration. With all due respect, Your Honor, it's completely immaterial. We are talking here about dates which she herself filled out. And let us not forget, Your Honor, please, if I may put it that way, that both COCs, 2012 and 2015, for the 2013 senatorial and for the 2016 presidential, are notarial documents entitled to the presumption of regularity and which are prima facie evidence of the facts therein stated. So, the Commission is of the position that if it is the position of Senator Poe that what is stated in her 2016 COC is the one that is true or correct, meaning 10 years and 11 months, therefore compliant with the 10-year residency requirement, it is her burden to prove that what she declared in her 2013 COC is the one that is false. The rule, Your Honor, that a person who claims that a present statement is false must not rely only on the falsity of the present statement, but must also show the falsity of the prior independent or prior statement. Does not apply here, Your Honor, because the first statement in 2013 contains an admission of the party, not declaration against interest under Section 38 of Rule 130. It is Section 6, admission of a party, the act, declaration, or omission of a party as to a relevant fact.
Relevant to the senatorial candidacy.
Yes, they be given in evidence against him. And that is the best evidence that affords the greatest certainty of the fact in dispute, Your Honor.
Thank you. Thank you, Chief.
Thank you, Your Honor. Yes, Your Honor.
Made a lot of pronouncements praising the fact that McKillen gave premium to the need for any elected official to have only one allegiance. Now, I wrote that decision. I did not say at all that the law frowns upon those who had formerly renounced his citizenship as long as their reacquisition complies with the present statutory requirement.
That is correct, Your Honor.
Okay, so I don't think you can overread into that anything more than what its intention was.
That is correct, Your Honor. In the first place, what Arnado did is different from what Poe did.
Yeah, so I don't think actually, in fact, that it is at all applicable because at this point, we were only talking about whether her affidavit of renunciation is effective or it had been recanted because of her continued use of the U.S. passport.
Yes, Your Honor.
Only to that. Okay, means nothing more than that. In fact, I was very careful to make sure that it does not spill beyond the required parameters for deciding on the matter.
Yes, Your Honor. Your decision really speaks for itself. It's a very well-crafted decision, if I may say so, Your Honor.
Thank you. And Justice Peralta seems to be chuckling. In Parts 1, Caballero, and Coquilla, does it take into consideration a former Filipino who had re-established or indicated residence prior to the acquisition? Were those the facts there?
No, Your Honor, but the court, in deciding those cases, discussed what could have been done by the candidates concerned or by the former.
Was there any evidence to show that before repatriation or requisition, there was the establishment of evidence? None, right?
Yes, Your Honor.
None. So the court was very clear that the decision applied to the facts as they presented themselves. That's why you have repetition of the truism that citizenship is different from residence, because the court was careful not to be confused on that point.
Yes, Your Honor, but the ratio decidendi in all of those cases was to the effect that Filipino citizenship is reacquired upon repatriation without effect on domicile, and domicile could be reacquired or reestablished if all those requirements are present.
But we did not say that prior to that point, domicile cannot be acquired, right? We did not. We never said that because it was a point that was hotly debated in fact.
Yes, Your Honor, the court said that domicile could be reestablished even prior to repatriation
Yes.
by certain acts like obtaining an ICR or ACR, which would have amounted to a waiver of non-resident.
Okay, so those were examples, right? Those were examples. In other words, the court was open to a situation where for the first time it would be presented with facts, whereby a former Filipino citizen who at the time that the person first tried to establish residence will then later on find out if that point can be counted in favor of that petition.
You're right, Your Honor.
Okay.
Yes, Your Honor.
Thank you very much. Now let me now go to the facts here before us, because I'm very curious as to what the court, the Comelec said about these matters. First question was the petitioner able to prove that she arrived in the Philippines on 24 May 2005?
That is stipulated by the party.
Okay. She was able to prove also that upon her arrival, she had her children with her mother in San Juan.
Although there was some resistance from then petitioner Ilaparo, now private respondent, because he said there should be adversarial proceedings. But when we examine the documents, the emails, and the submissions of Attorney Garcia, we found that as fact, and that is enumerated in the findings of facts, Your Honor.
So she was able to prove also that she secured a TIN, right?
Beg your pardon.
A TIN, a tax identification number in 2005.
For purposes of the estate of her late father, Your Honor.
Yes. She was also able to prove acquisition of a parking slot and eventually a lot also in 2005 and 2006.
Although we consider, yes, Your Honor, but we consider that doubtful because how can a U.S. citizen acquire land in the Philippines?
A condominium unit, an alien cannot acquire land?
Condominium unit is a different story, but there is
I'm talking about a condominium unit.
Yes, Your Honor.
The parking slot is part of the condominium unit acquisition, right? You don't say that is land, no? The parking slot.
It's part of, if it is part of the contract for the unit, yes.
Yes, so it's part of the condominium unit. And then she was able to prove that she and her husband sold the family home in the U.S., correct?
That is an allegation, Your Honor, but we did not see hard evidence on that. The deed of sale was not presented other than the claims, receipts, Your Honor.
All right. Let me turn your attention to page 56 of the Comelec comment. It says, the Comelec noted the following facts as duly proven by the petitioner. Petitioner's children arrived in the Philippines during the latter half of 2005. Shortly after their arrival, petitioner's children began their schooling in the country. Petitioner purchased a condominium in San Juan City during the second half of 2005. Petitioner and husband started the construction of their house in 2006. Petitioner and her husband informed the U.S. Postal Services in 2006 of their abandonment of their U.S. address. What does the Commission mean when it says that these facts are duly proven?
Your Honor, the proceedings before the Commission was formally, there was a preliminary conference submission of exhibits, stipulations, comparison between the originals and the photocopies, and offer of evidence. We consider these facts as non-controverted in the sense that they are covered by documentary proof, Your Honor.
In other words, while you have admitted them, you did not, from that alone, make a conclusion as to their probative weight.
We did.
What did you say about these matters that you say have already been duly proven?
Assuming all this to have been done or to have taken place, they do not serve to re-establish residence or they do not prove the acquisition of domicile for the simple reason that all these were done prior to her repatriation, as in fact any resident alien could do these things in light of countervailing circumstances.
Wait, okay, let's not go to countervailing circumstances first. You're saying because they are prior to the acquisition, they do not count?
Coquilla, Your Honor.
But we did not say in Coquilla that if Coquilla had proven acquisition of residence among the jurisprudence that we had already laid down, that we would have said that he was not able to acquire residence prior to repatriation. We never said that. So you went one step more than what we did.
No, Your Honor.
You mean counsel that in order for an alien who former Filipino who reacquires, he has to start all over again. Okay, that is now his oath of citizenship, July 2006. Then he has to start again, arrive in the Philippines, enroll the children again, acquire properties again. Is that the scenario you are talking about, counsel?
No, Your Honor.
What do you really mean?
Your Honor, please, Your Honor is, with all due respect, missing the most important element, which is that these acts, like arriving in the country in the later half of 2005, enrolling our children in June of 2005, opening school, purchasing condominium unit in San Juan in the second half of 2005, and construction of their house in 2006. All this, Your Honor, took place before July 20, 2006, when she repatriated, and in the light,
Question. Are you now laying down a new rule that we have never yet laid down, that there cannot be acts of acquisition of residence prior to reacquisition of citizenship? This is a new rule. You can't find this in any other previous jurisprudence.
It's not a new rule, and Your Honor, I was not able to complete my sentence, Your Honor. The rule laid down in Coquilla is that, and also in Caballero, is that re-establishment of domicile is effected upon repatriation unless prior to repatriation there is a waiver of non-resident status. All these acts were performed prior to July 20, 2006, and up to July 20, 2006, there was never a waiver of non-resident status.
We never said that it was an absolute sine qua non for that to happen. In fact, you admitted that earlier, that the situation that we face is completely different. Here is a situation where the petitioner is proving not just a short stay here, but an entire relocation plan. We never said that if a person applies for the cognition of the residence and asking the court to credit even all the time that she had implemented an entire relocation plan, that we would strike that down. We had never said that at all.
Because Your Honor said that prior to repatriation, if there is
Because Kenya never presented any evidence of what he did beforehand. He was here in and out, in and out. Now, I am asking you, in light of this, you are now saying all of these areas, you will just jump.
no, Your Honor, no, Your Honor.
Because you can only take cognizance of acts that happened after the acquisition of citizenship.
No, Your Honor, that would not be accurate with due respect because the Honorable Chief Justice failed to factor in the fact, undeniable fact, that all this time, from May 24, 2005 up to July 2006, the petitioner was in the country, sojourning in our country, only as our laws on aliens would have allowed her to do so. Specifically, she was here on a visa-free Balikbayan visitor program.
Commissioner Lim, we're running around circles. Precisely, my point is, you're basically asking me to recognize and in fact make an extension to say that Tokila et al. Says that all acts prior to repatriation are not to be recognized. That's the core issue, and that's the core issue before this court. Are we going to go to that extent of saying you cannot establish a period of residence prior to the acquisition of citizenship? But you see that is logical because we took great pains to separate residence from citizenship. Residence has to be satisfied by the 10-year rule, citizenship at the time when, natural born citizenship at the time when the application for the survival certificate of candidacy is being done. Is that right? Now, if you say that residence cannot be acquired except from the point when citizenship is to be acquired, then all our effort to distinguish the two are gone.
Let me put it this way, Your Honor, please, if I may. If in this scenario portrayed on the screen, Mrs. Poe came here not on a visa-free Balikbayan visitor program, but acquired an ICR or an ACR, I would be the first to say that she would have re-established residence. But she did not do that, Your Honor. She remained a U.S. citizen and she remained a U.S. resident. She was here as a temporary sojourning alien, although formerly Filipino.
You are trying to say that a Filipino who comes here for a visa-free program suffers an impediment. But she complied with the law, right? Did she come here illegally?
On a visa-free program, Your Honor, but for 1 year, which she allowed to lapse.
But can it not be renewed? She left again, right? And we didn't mention.
She did not renew, instead, she...
Did she come here illegally?
No, Your Honor, because she came
She
here.
had the right to stay with her mother since May.
That is now the point of contention, Your Honor.
Did she have the right to enroll her children?
Yes, Your Honor, but non-resident aliens would do the same, Your Honor.
Okay, so if she did not suffer from any legal impediment to perform the acts that to us are acts of residence, you know the case of Hernandez versus HNet, right?
Yes, Your Honor.
Where we credited the schooling of the children as an important indicator of acquisition of residence.
The court laid down in Hernandez versus HNet the real and substantial reason rule. But that does not apply to Mrs. Poe because there was no renunciation of Philippine citizenship. And Mr. Fernandez, simply by his business interest in Santa Rosa and by his act of enrolling his children and buying property, the court deemed him as having acquired residence in
So you
Santa Rosa.
basically are saying the question that you're asking them, have you fulfilled the requirements of 10-year residence? Can you put it in Filipino first? Anong ibig sabihin ng material misrepresentation? Would you have Filipino translations for material misrepresentation?
Unfortunately, I have difficulty
O
with
Filipino
Tagalog.
pa rin. Both of us are Filipinos.
With Tagalog, Your Honor. But I agree with that.
Is it
that would be
Tingin lang,
too literal.
pagsisinungaling. What if it's too literal? What do you want? You want a figurative
You are
interpretation?
asking this representation to translate material representation.
Because it is important, because remember, this is an electoral exercise.
Yes, Your Honor.
And the ones who are going to read the documents are Filipinos. And when you say material misrepresentation, matinding pagsisinungaling sa importanteng bagay.
I cannot believe that, Your Honor.
Is that correct? So, sinungaling.
Pagsisinungaling sa isang
Sinungaling sa isang mahalagang bagay.
material na bagay.
So, when she came back here in May 2005 with her children and enrolled them in June 2005, and now she claims that at that time they really intended to stay here. Who is she lying to right now? Is it to the Comelec or to her children? Are you saying that when she brought her children there, she told them, children, we are not going to stay long. I'm only going to enroll you temporarily. Is that it?
Can I answer your
Yes.
question? May I repeat what I said earlier in one hearing? That the truth in actual life is not necessarily the truth that comes out or that is required in a judicial proceeding. In actual life, you tell your children, we are back in the Philippines, so welcome to your new home. But this is an electoral exercise impressed with great public interest, where there are requirements and rules and parameters to be observed. You do not just simply say, this is now our residence. What about the consent of the husband who remained in the U.S. all the time? It cannot yet be considered in law as a family home or a family domicile. But in actuality, maybe, in layman's terms, maybe. But we are here, precisely we are before the court because we are talking about law, Your Honor.
Earlier, you were, in fact, justifying Mr. Mitras having been considered by the court of his residence in Aberman because it was made necessary. In other words, you were saying, of course, he cannot do anything otherwise because it was required by the law. Now, you are saying, and then you said that in fact the court gave life to the intention of Mitra that while he was trying to construct his house, he of course had the right to claim as his residence the mezzanine of a feed mill. Now here you have an entire family relocating, removing all of their belongings and relocating here in the Philippines and enrolling their children, pulling them out of American schools. Philippine schools right now, are they at the same level in terms of international prestige as American schools?
I'm not aware, Your Honor.
Okay, of course, that is something that we can very well address in the memorandum, but I'm sure that there would have been disadvantages to our children by them having been pulled out and enrolled here in Philippine schools.
Your Honor.
Okay, let me finish. Commissioner Lim.
Yes, Your Honor.
I don't think that we can ever say that our judicial pronouncements does not necessarily reflect the truth. The truth in life, as it operates before our eyes, is the truth that must be carried in our judicial pronouncements.
I agree, Your
So
Honor.
that when we say that she is materially misrepresenting herself, we are basically telling the Filipino people that when she went back to the Philippines with all of their belongings, enrolling their children, and until now staying here in the Philippines, that she continues to lie to us, that she has no intention to stay. And that is something that is a very serious statement for any court to make.
May I respond, Your Honor?
Yes.
Your Honor, please, may I respectfully invoke your own ruling in Sabili that the appreciation of evidence and evaluation thereof must be on the basis of a total approach. Evidence cannot be considered in isolation. With all due respect to the Honorable Chief Justice, lacking here, Your Honor, lacking here are the non-waiver of non-resident status, the decision of the husband to remain in the U.S. As in fact, he came to the Philippines only in the later part of 2006 after repatriation. And the fact, Your Honor, that the animals no longer tending, despite all this, still remained. There was ambivalence, if I may put it that way, on the issue of whether or not the die is cast. We are back in the Philippines for good. There is ambivalence, Your Honor. So the reacquisition of domicile is doubtful.
So you doubt someone, a mother who forced all her children out of American schools, you doubt her resolve to be in the Philippines when she enrolls them, you doubt her resolve when they acquire properties, you doubt her resolve even after 11 years they're still here, and their children are still studying.
Taken in isolation, I cannot not agree with the Honorable Chief Justice. But the totality, Your Honor,
Yes, you keep on saying about the totality of evidence. You see, Commissioner Lim, the reason why I'm disturbed by your constant invocation of totality of evidence is I myself went through great pains to examine each piece of evidence in civility and relate that in relation to other pieces of evidence. I don't see it here. You are just saying that even if all of those are already stipulated and proven, we throw it away because there is no resident visa. That's the only and actually what you're making is just a legal conclusion that a resident visa is a condition sine qua non, and other than that, all of those do not matter.
but that is in jurisprudence, Your Honor.
We did not ever say that you cannot prove residence. If you do not have a resident visa, we never said that. We never said that.
We will address that in our memorandum, but the holding in Trujillo and Caballero was that we established lot of domicile.
You put that in your memorandum because you have put words into our mouth in a situation where we were not confronted with something similar. This is the first time we're going to encounter a situation where the relocation preceded the acquisition.
Mitra also, Your Honor,
No, citizenship. Where citizenship was involved, the acquisition of citizenship was involved. This is the first time. So you have to address that because that is an open question and we need to figure out the solution to that.
we will try our best to assist Your Honor.
All right. Now, when you come, you see, you've thrown out the fact of relocation, continuous schooling. You've thrown that out. May I now ask you what you did in looking at the email that they submitted dated 18 March 2005? Have you looked closely at that email?
Yes, Your Honor.
Okay, and can you tell us what that email says?
This correspondence says, email correspondence says, it is a desire to bring the belongings here to seemingly on the surface, Your Honor, to transfer residence here and to inquire about the cost of moving to the Philippines, Your Honor.
Did you look at how much they were planning to move back to the Philippines?
Well, they said they sold their house there already, Your Honor.
28,000 pounds.
Yes, Your Honor.
28,000 pounds. And the estimate of the forwarding company is that they need 3 40-foot containers, correct?
The question is to go.
Okay.
That, Your Honor.
Including, can you look at what a 40-foot container looks like? This is please look at this, Commissioner Lim.
I'm quite familiar, having been a maritime lawyer.
Yes, all right. Thank you very much. You see, one 40-foot container already contains an office and entire residence. And then if you put 3 on top of the other, okay, that's already the content of an entire house. And they're talking about glass tops, marble tops, chandeliers. In addition to that, 2 cars and pets. Of course, it's not in the email. In other words, Even this, there is no intention. Commissioner Lim.
Your Honor, I really hate to disagree with the Honorable Chief Justice, but those data beg the question, if I may put it very respectfully, on whether or not, considering all that, in the absence of the husband here, in the absence of a permanent resident status, whether domicile has been re-established, because there are three requirements for re-establishing domicile.
You mean the domicile under the civil code is the domicile under the election law? You know that that's not true, Commissioner Lim.
Yes, Your Honor, for election law.
You know that for election law purposes, we can maintain our domicile. When we were single, and then we got married to our husband, although we are under the civil code, required to follow his domicile, under the new family code, the domicile is not to be jointly fixed. You know that I can maintain my own domicile for purposes of election? Let's face it.
Marcos Romualdez
Correct.
is to the effect that the court presumed Mrs. Marcos did not follow the domicile of
It's not. So why are you not taking it against her that her husband remains in the U.S.?
because of the need to re-establish a family home to be jointly decided by the husband and the wife.
But eventually the husband followed, so why are you picking on it?
That's why we are computing residence, Your Honor, since 2006, not
So in
2005.
other words, if the husband does not follow the wife to the wife's establishment of her domicile, that will be taken against her for purposes of her right to run for public office? I think that's too discriminatory.
I was just pointing out, Your Honor, even in the context of marriage, a family home or a family domicile is jointly decided by the husband and the wife.
Yes, that's true, and we like that. But for purposes of election law, can you take it against a wife that her husband is not living in the same residence that she is living in? No. Why are you now picking on the fact that the husband remains in the U.S. a few months into 2006?
That is circumstantial evidence that the Commission considered, Your Honor.
All right. Now we go to what you are saying. So what you are saying is we can actually say she has lied and misrepresented everything about her regarding her residence, even though the reality is she was here all the time.
I would hate to use the word lying, Your Honor. If there is a more proper term, I would say it, Your Honor.
She was dishonest.
No, Your Honor, that was misrepresentation, Your Honor.
Innocent misrepresentation.
Material representation that was false. That is the wording of the law. I would prefer to use the law, Your
You know,
Honor.
either she is telling the truth and she is consistently telling the truth to her children that they are going to stay in the Philippines, or she is lying and she is fooling her children and they are going to fly back to the U.S. anytime.
Well, Your Honor,
The reality has only one face here. Either she has decided to stay here animus monendi and has forsaken animus revertendi to the U.S., or we are going to be too technical to the point that we are denying what the reality is.
Your Honor, the reality is that she arrived May 24, 2005 and renounced American citizenship only on October 20, 2010. 5 years. Unlike Comelec, 4 days after arriving from Australia, he immediately renounced Australian citizenship.
But she was here legally.
Well, yes, Your Honor, visa-free Balikbayan program.
Does it say in any statute that she has to immediately get a resident visa with her?
Well,
Or is this a new imposition by the Comelec?
No,
And
Your
if
Honor.
you are making a new rule, are you not in fact exceeding your jurisdiction? We are going beyond what the law requires.
We are not making new rules. We are aware of our limitations, Your Honor.
All right.
We always follow the Supreme Court.
You have already discussed the fact that we have discussed monthly domestic adoption laws. And in that law, there is a very specific section on effects of an adoption decree. Correct?
Yes, Your Honor.
The provision says the decree of adoption shall be entered amended birth certificate. And the birth certificate will not put on its face the fact that it is an amended one, and all records and proceedings on the same shall be considered as sealed. How many types of certificate of birth do you know of?
Except birth certificate,
Types of birth certificate.
times.
Types, yeah, kinds. Only one, right?
Yes, Your Honor.
Because there is no certificate of dead birth.
Yes, Your Honor.
There is only certificate of live birth.
There is, Your Honor. Certificate of live birth.
So all our civil registrars have, from the moment that the adoption decree is given to them by the court, issued certificates of live birth.
That's correct, Your Honor.
And what does it say? Does it say where a foundling has been adopted? Does it identify the parents?
No, Your Honor.
No, I'm talking about the certificate. Now, what you're going to say is very, very important because it will affect the work of our family court judges. Does the civil registrar, not in fact, put as the name of the parents, the names not of the biological parents, but of the adoptive parents? Do they not in fact do
Yes, Your Honor, in case of adoption.
correct? So, and in fact, these are already considered as binding and confidential. And when it is transmitted to the Department of Foreign Affairs, does the Department of Foreign Affairs issue a passport to these adoptees?
Yes, Your Honor.
On the basis of what?
That certificate, Your Honor.
Certificate of live birth. Do you know that the Department of Foreign Affairs even gives passports to foundlings?
Well, that's the practice now, Your Honor.
In which means when a person who has been adopted is required by the court, in fact, to live by the certificate of live birth, that person is required to live as if it is true, completely. It is a legal fiction that has been created by law. Is it not true?
Yes, but can I say and point out, Your Honor, that it does not at all impact on natural born citizens?
Why not? Why will, okay, but can it not also impact the question of misrepresentation? So that if a person who has the benefit of a certificate of live birth says born to the adopting parent and the adoptive father and the adoptive mother, is that person lying or not? Or is that person only complying with what the law is saying?
In the hypothetical situation that the Honorable Chief Justice is drawing before us, it's not necessarily the situation of the petitioner, then that would be a factual, a correct statement to make.
But we cannot make a distinction between her and say, she, petitioner, is lying, but for all the other adoptees, they are not lying. If they indicate in any form that their parents are their adopting parents, either we say she can put the names of her adopting parents or we say she cannot. Only that. We cannot say, make a special case only for her, but for all other adoptees, allow them to continue putting the contents of the certificate of live birth.
Well, let me put it this way, Your Honor. We are not discriminating against the petitioner. We are not singling her out because she is running for president. But there is a more careful scrutiny of her eligibility because she renounced Philippine citizenship once upon a time. And in reacquiring, as pointed out by Justice Carpio, she had to fill out certain forms.
So when she was issued a passport by the DFA, whatever data the DFA considered cannot anymore be put in the BID form. She will have to completely live a new set of facts. She will have to correct all her records now, considering that she has a final degree of adoption in her favor.
Your Honor, the court has ruled in some cases that possession of a Philippine passport does not necessarily prove Philippine citizenship.
I know, but you are also saying that she falsely misrepresented herself. She lied. When she put the names of Fernando Poe and Susan Roses in the question on who her parents are.
In the BID, Your Honor, not in the DFA.
In the BID.
Yes,
Pero,
Your Honor.
and what was she going to put there? She's going to ignore the fact that she has an adoption decree. She's going to ignore that she has a certificate of live birth. What are you going to require all adoptees now? Because whatever we say here will now be the rule for all adoptees.
Your Honor, please may respectfully point out that adoption does not confer the citizenship of the adopted.
I never said it does.
And
I never said it does. But you were saying born to. Yes. And the certificate of live birth says born to. So are you now saying she cannot use the facts that are being issued by the civil registrar herself in her forms, that she cannot make use even of the cases where the court has already presumed that those with unknown parents or those with parents who have abandoned them but whose Filipino parentage is not proven are presumed to be Filipino citizens. She cannot even make use of those?
Yes, Your Honor.
Why not?
She cannot, Your Honor.
Why not?
Yes, I'm answering, Your Honor. She cannot, Your Honor, please, for the simple reason that the law, the enabling law, under which she is exercising this privilege, RA 9225, is reserved by express provision of that law only to former natural-born Filipino citizens.
But she believes that she's a natural born.
It's not, Your Honor.
Well, that's your legal conclusion. And because of your legal conclusion, you have already drawn the conclusion that anyone who does not believe in your legal position is lying.
No, Your Honor. I did not go to the extent of doing
No,
that.
because you said,
There is no infallibility, Your
if
Honor.
you are a foundling and you claim you are a natural born, then you're lying.
Under the
Just
Constitution.
imagine, she will be disabled under all grounds. She lies because she claims she is naturally born. And on top of that, she is not even natural born. So she has absolutely no claim whatsoever, no right whatsoever.
Your Honor, please, we will tackle this in our memorandum, Your Honor. Our principal submission is, firstly, she is not natural born, assuming that she is reacquired under 9225, not natural born status, and therefore not eligible, Your Honor.
Now, let me go back to the process. If you are using all possible legal tools to construe all the evidentiary interpretations against her, making admissions against interest as the same as judicial admissions. And admission against interest only has to do with their admissibility, not with respect to their probative weight. But what you did is to convert her 2013 COC into a document as conclusive and as binding as a judicial admission, and throw out everything else, contrary to what you were always praising as the totality rule in Sabili. I do not find any resonance between Sabili and your approach. Can you tell me how you are able to justify this under Sabili?
Your Honor, we evaluated everything. And the petitioners, I have said this quite a number of times, submitted the citizenship issue on alleged presumptions of natural-born citizenship under international law. The Comelec, just like a court, although we are not a court, passively receives evidence. We do not solicit evidence, Your Honor. We do not tell the parties present this or that to us. We decide on what is presented before us, and they stipulated the question of fact, Your Honor, was, is the petitioner a founding? If so, is he natural born? So it's a combination of fact and law. They submitted it in that way. And, Your Honor, please, when the parties admitted, especially the petitioner, that she is a founding, and that was the opening salvo in the verified answer, everything else was just to apply the Constitution, Your Honor.
Everything else, the Constitution according to you. And therefore, every intendment is against, therefore, the application, because from the beginning you said, she really cannot run.
No, Your Honor. No, Your Honor. Wait divisions. I can say this for a fact, Your Honor. I should not be saying this because it's part of our confidential deliberations. We fought for her right to run. The second division resolution disqualified her only on the ground of residency. And this representation was very vocal about citizenship. Why not give her the benefit of the doubt? But because of the motion for partial reconsideration, we had, at least for a moment, to act as judges, try to simulate the life of the judge. Divorce emotions, rid ourselves of emotions, rid ourselves of feelings of sympathy, and decide it according to the evidence and the law. It was only in the end when this representation, together with another colleague, voted to disqualify her on both grounds. We were very deliberative, required, Your Honor, in discussing our resolution.
When there were also objections, Counsel, that she should not have used her U.S. passport when she was traveling to the U.S. before her oath of renunciation of her U.S. citizenship. Do you remember those objections?
Yes, Your Honor.
What is your response to those objections?
Well, Your Honor, there is no evidence presented by the private respondents now that the case of Arnado is applicable. There is no evidence presented before Comelec that she recanted her oath of renunciation of U.S. citizenship by using her passport after renunciation.
In fact, it is illegal for a U.S. passport holder to enter and leave the United States and use a passport different from the U.S. passport. Yes, I found out because there were objections saying, why did she not use her Philippine passport at the time that she was a dual citizenship if she loves her country? And I found out that in fact it is illegal. For dual passport holders, the advisory of the DFA is always use the U.S. passport, citing 8 U.S. Code SS 1185.
We did not fault her for using her passport before renunciation, Your Honor. And that is not in our decisions, although in the first division and bank decision, there is mention about using passport repeatedly, Your Honor. But we, the Commission, did not give counsel for that because that is a right as a dual citizen.
All right. I have also gone, because this is a case of first impression, because you keep on insisting, only having held a resident visa could save her bid to be a candidate for the presidency by May 2006. If she did not hold a resident visa by May 2006, all her hopes of running cannot be granted because she does not meet the 10-year presidency. Is that correct?
Yes, Your Honor.
Okay. So I tried to find out, because this is the first time that the court is going to face the situation. If there are, in fact, other jurisdictions that has a view on this. Now, I will not prejudge, but I want you to look at it in your memorandum. I have looked at two. Elkins versus Moreno, 435 U.S. 647, and Toll versus Moreno, 284 MD 425, 78 and 79. In the case of both instances, they were considered as holders of a visa that would not have allowed them a long-term stay. So it was not a resident visa that had been granted in these two situations. And yet the court said that for purposes of establishing domicile under election laws, it is possible for the holder of such visas to establish residence. Can you look at that in your memorandum and find out, in fact, And then I would want you to discuss the four types by which domicile and residence are being considered in Philippine law. Would you know what these four approaches are?
We'll research on that.
Okay. Of course, right now we are looking at residence for purposes of either being able to vote or being voted upon. And our legal standards there is actual residence. And if there is a conflict between two residences, the animus manendi and the non-revertendi to the former residence, correct? Okay. We have also domicile and residence under the civil code. We have also residence under naturalization laws. And we have also the concept of residence under taxation. What I want councils to help the court is not get confused, so that we will maintain the consistency of our jurisprudence by focusing ourselves on election laws vis-a-vis the rest of the requirements, because each type of residence requirement under law has a specific purpose. For purposes of naturalization law, it is for purpose of regulating, controlling the presence and visits of aliens. Naturalization law allows, in fact, the recognition of multiple residences. Election law does not allow that. On the other hand, especially for one running for an elective office, you only have one residence. Taxation has a different purpose. It is for finding out whether there are incidents of taxation over which jurisdiction can be acquired. And the civil code on the person's, on the status of a person that can have also a different date. I want you to address that so when we make our decision, we maintain the integrity of jurisprudence on elections. So kindly look at that for a purpose. And I also want you to focus on the Balikbayan law, all of you, to find out if someone who enters the Philippines using a Balikbayan visa cannot avail of its terms for the purpose of establishing a residence. I want you especially to look at the economic provisions of the Balikbayan law, its focus on livelihood, and its focus on reintegration, taking off, in fact, from the argument of the Solicitor General. We are the first to welcome these. So what really is the policy of the state for Balikbayans? Are we considering them second-class citizens? Because, corollary to that, in addition to the second-class citizens argument that had been raised by Justice Ordileza, I am starting to suspect that we are creating another set of second-class citizens, which are repatriated Filipinos. So this is very important to us because that will impact how we also view RA 9225 and the entire program, and in fact the entire policy of imagining the Filipino nation as not only those who are actually residing here, but also our brethren abroad. Can you please speak about that in your memorandum?
Yes, Your Honor.
Okay, thank you. Is there anyone else who wants to ask a question from the... Okay, Justice De Castro, please.
At one point, you are focusing on the requirement that the resident visa must be waived. Before you can count residents in the country, there must be a waiver of permanent visa in the U.S.
Yes, Your Honor.
Now let's see the implication of not waiving permanent residence. If the permanent residence in the U.S. is not here, they can always go back to the U.S. anytime.
Definitely, Your Honor.
Now, even if you are a dual citizen, and you do not waive your permanent residence in the U.S., you can always go back.
Yes, Your Honor. The animus non-revertendi is absent.
So, in the case of the children of the senator who are dual citizens, and if they have not waived their permanent resident visa in the U.S., then they can always go back after their college education.
Yes, Your Honor. And besides, Your Honor, Honor, it's not the children who fix the residence of the petitioner.
I just mentioned that because that was one of the factors that they mentioned to say that since the children came back to the Philippines to study, then that should be taken into consideration in finding the fact that the petitioner has transferred to the Philippines permanently.
Yes, Your Honor.
Justice Perez, Justice Leonen, and then Justice Reyes who also want to ask question. Justice Perez and then Justice Leonen.
Did you or did you not rule on the qualifications of petitioner Poe for to be a candidate for the presidency, namely the qualifications on citizenship and residency? Did you or did you not rule on these points?
We followed Fermin, Your Honor.
I'm asking for an answer. Did you or did you not rule on this?
We made a ruling on material representation that is false.
And how did you do so? How did you reach the falsity of the representation?
There was a justiciable case. We summoned the parties to a conference, exchange of exhibits, and then there was a hearing, submission of memoranda, stipulation of facts, and then we deliberated. We argued among and against each other, and we arrived at the decision.
And the decision is a decision on what?
There was a material representation that is false. Because she stated in her 2015 COC, first, that she is a natural born Filipino citizen, which is false, and that she is compliant with the 10-year residency requirement, which again is false because in our finding, Your Honor, we found that the earliest possible date when she re-established Philippine residence was on July 20, 2006.
Which means that your finding is that she does not have the residency requirement.
She failed to meet the residency
And
requirement.
she is not a natural born citizen.
As required by Section 2, Article 7 of the Constitution, Your Honor.
Just please discuss in your memorandum why, being the case, you did not resort to Rule 25, which is the specific rule on a disqualification of a candidate.
Your Honor, the case before us was Section 78, petition to deny due course or to cancel COC, Your Honor.
And you cannot, it is not within your power to say that your petition is not a petition for cancellation of the certificate of candidacy because it is in fact a petition for disqualification of Poe as a candidate.
No, Your Honor, the petition was on Section 78, and our mandate was to find out if there was a material representation that was false with respect to eligibility on citizenship and eligibility on residency. Because residency and citizenship, Your Honor, are required under Section 74.
Yes. Okay.
Justice Leonen, I just have a few technical questions just to make sure that I get your position very clearly. The jurisdiction of the Comelec in Section 78 is with respect to whether or not to give due course to a certificate of candidacy. Is this correct?
Yes, Your Honor, on the determination that there has
The
been
certificate of candidacy in this case is the certificate of candidacy for president. Is this not correct?
Yes, Your Honor.
Second question is, if everyone is presumed to know the law, that's a premise. If everyone is presumed to know the law, can anyone misrepresent the state of the law?
Yes, Your Honor, if the law is very clear and leaves no room for doubt, and you utilize the law,
So the assumption is that everybody knows the law, so it is still possible for anyone, any single person, to misrepresent the law to anyone.
yes, Your Honor, there can be a misrepresentation of law.
There is a contradiction there. I hope you can cover that in terms of your
Your Honor.
My next point is, domicile, once established, cannot be changed.
It may be changed.
Just to clarify your position, it can change, correct?
It can change.
So domicile is not for forever.
It's not for forever.
Yes, walang forever.
Yes, Your Honor. Yes, Your Honor.
And once a person has a domicile, it is not possible for that person to own properties in another territory. True or false?
If you are domiciled,
Theoretically, if somebody is domiciled in a certain place, that person, without risking that domicile, cannot have properties somewhere else.
it depends on the law of the country where the property is found.
Can there be properties in another place of a person domiciled? For example, here in Manila.
In the U.S., there are many Filipinos owning properties there, Your Honor.
I need a categorical answer just to be sure.
Yes, Your Honor, yes.
Okay. That's all. Thank you.
Thank you, Justice.
Justice Bersamin.
Good afternoon again. May I also ask later the Tribune of the People?
I was going to ask you if there are any more questions for Commissioner Lin, then we will discharge him and then we call on the Solicitor General.
Yeah, I had a question.
For Commissioner Lin.
Mr.
Okay, yes.
Yes, good afternoon. You remember our conversation about animus manendi, animus non revertendi, and the subjective and the subjective and the objective elements that go into the determination of domicile, also known as residence.
Yes, Your
That's a law. Now, when you in the Comelec consider this issue of domicile, which is equated or synonymous to residence as a requirement for candidacy, do you consider evidence also that would prove not necessarily a continuity of physical presence?
Yes, Your Honor, we considered everything that was placed on record.
Let me go to a hypothetical situation. Here is a Filipino citizen who travels very frequently to the United States of America or to other places in the whole wide world, stays away maybe 8 months or 10 months a year, goes back, only stays in the Philippines for 2 months at a time, and then he does this for the past 20 years. Do you question this residency?
No, Your Honor, because of the principle that your residence or domicile for election law purposes is when you wish to return or when you wish to go back, wherever you may be in the world for business or leisure or what have you. It is your fixed permanent abode.
Yes. So those people who went abroad during the height of martial law to avoid persecution, to avoid violence, etc., and you are aware of those famous names, Salunga, Alvarez, who else stayed away. There was no question at all, even if they had green cards, that they were domiciles in the Philippines.
In fact, Your Honor, possession of a green card results in abandonment of residence, and that is our jurisprudence.
That is what you follow.
Yes, Your Honor.
All right. I was asking you then about last time maybe. I was asking you then about the effect of dual citizenship. Did you consider the petitioner a dual citizen when you decided her case at one time in her life? She was a
dual citizen once upon a time.
In the context of Republic Act 9225.
Yes, Your Honor, prior to her repatriation.
So we do not have any issue about that.
Well, Your Honor, please, as to natural born status, we have an issue.
Yeah,
But as to the fact that she reacquired Philippine citizenship or naturalized citizenship, that is one issue. I will not call her stateless, Your Honor.
Yeah, of course, I agree with you on that. But because you were mentioning a while ago in answer to your, in your exchange with Justice Carpio that 9225, the terms of that law would not help her as a dual citizen because you did not consider her a natural-born citizen.
Yes,
You are still detaining.
petitioner in the view and in the decision of the commission, the petitioner is not natural born, and when she became naturalized in the U.S., she lost her Philippine citizenship, and she could not reacquire a status that she never possessed. I'm referring to natural born, Your Honor.
Okay. Now let me go back to the substantive and subjective and objective standards for determining residency. And I also would like you to refer back to your exchange with the Chief Justice regarding totality of evidence. And I think that this animus thing about domicile can only be established through circumstantial evidence.
And overt acts.
Yes, overt acts make up circumstantial evidence.
Yes, Your Honor, because
You cannot establish that by direct evidence because you would be having perjury most of the time.
you cannot enter a person's mind, Your Honor.
Yes, and only his manifest acts manifest what the intention really is.
That's correct, Your Honor.
Right. Let me test you a little bit more. There are three kinds of circumstantial evidence. You still remember? The prospective, the contemporaneous, and the retrospectant. You still need more to be reminded about this?
You just reminded me. It's
So, if something happens after a supposed date, something happens which looks back to that date, you would consider that as evidence, retrospectant evidence, without intention or whatever happens then.
yes, Your Honor.
And if anything happens before that date, that would be the prospectant. Okay? Now, you are clear enough about the petitioner having come back to the Philippines from her United States sojourn in 2005.
May 24, 2005.
But yet you would not consider that to be the start of her residency in the Philippines because as of that time she did not yet waive her residency there.
Her non-resident status. Yes,
Non-resident status.
yes, Your Honor.
But the record is very clear that she stayed here. You admitted that she sold her house there and then she brought her 3 children here, enrolled them, did other things that would be done here only by somebody who is interested in heart and soul to stay in the Philippines.
2 of the 3 elements we admit were already present, but the third element, which is equally important, or if not more important, was lacking, which is the animus non-reverendum.
Non-reverending.
She could always have
Yes.
come back.
I'm going into that. And the only reason why you would withhold from her this residency from 2005 is what you call the absence of the proof of animus non-reverending.
That's correct, Your Honor.
All right. Ultimately, she came back and waived her residency in the Philippines. When was that?
The earliest possible date was July 20, 2006.
2006.
The strictest date, if I may use that word for the first time, would be on October 20, 2010, when she renounced U.S. citizenship. But that is going beyond the decision.
Yes.
We stand by our finding of July 20, 2006.
Okay. Good. That's good. Now, from that time of 2006, there is a difference of 1 year from the time she came back in 2005.
almost one, yes, more than a year, Your
All
Honor.
right? Why don't you credit her with that? For purposes of reckoning her residency for election purposes.
Unfortunately, Your Honor,
That is retrospective. It looks back to the time she started in 2005 her residency here.
Your Honor is correct, if I may put it that way, with all due respect, if that retrospective evidence is taken in isolation and allowed to stand independently by itself to try to convey whatever probative value it may have. But circumstantial evidence, as we all know, Your Honor, is more than one circumstance. It has to be interconnected, interrelated to produce a factual result.
Yes, there was a link, there was a chain of so many things that
Yes, Your Honor.
right from the start 2005 up to the present, she's still here. All these are circumstantial evidence of an intention to remain. Is that not what you would
But as I pointed out to the Honorable Chief Justice, we did not factor in temporary sojourn on a balikbayan visa, which by its nature is just temporary. It cannot confer resident status because a visa-free balikbayan entry is anathema to animus non libertendi.
o balik bayan na, balik bayan.
But she is here on temporary stay under the balikbayan law, and therefore she could always go back to the U.S. She did not waive her resident status. So, Your Honor, what this representation is saying, Your Honor, is that the retrospective circumstantial evidence cannot prove the establishment of evidence in isolation by itself.
Okay. Maybe we will discuss this later, but here is another thing. I was mentioning to you also before about this law that was passed. The main author of this law was Senator Rocco. That's why he earned the very unique title of Woman of the Year, Honorary Woman of the Year. He sponsored this law, and this law has been in effect for a long time now. This is the Women in Nation Building Act. You're aware of this law.
I have heard of it. Honestly, I have not studied it thoroughly.
This is a declaration of independence for women who are not better than men.
Yes, Your Honor.
And this law precisely gave to women the parity with the men. And it is no longer correct for anyone to say, despite the existing provisions of the Civil Code and the Family Code, that it is the husband who fixes the domicile.
That's correct, Your Honor. Joint decision now.
Yes. And the woman can maintain independently her domicile under this law. Would you agree?
Yes, Your Honor.
So, in the eyes of the Comelec, if a woman comes to you and says, I am a resident of this place, but the husband is a resident of another place, would you consider that material misrepresentation on that basis?
We would consider it in the totality of the other evidence, Your Honor. If that were the only evidence, then the objection of the man would be unavailing in light of the law you have just cited, Your Honor.
Okay, here is another hypothetical situation, and you will have many of these when you go back to Comelec. Here is the wife of an incumbent official. Both of them have voted maybe one or two elections already in the same municipality. But here is now somebody who questions the wife who is now running for a particular position in that municipality where she has voted. And there is proof that is submitted to you that this woman has no contact at all, no minimum, not even an actual residence in that place where she has voted. but her actual residence is in another municipality, which, if that is true and established, would disqualify her from running for public office in that other municipality where she has been a voter all these years. Would you consider that to be anomalous so that you would cancel her certificate of candidacy on the basis of material misrepresentation?
Maybe that can be the result, Your Honor, because mere
What is
registration
that again?
and candidacy may be cancelled. I'm not saying it will, but it might be subject to cancellation because the mere fact of being a voter in a particular locality.
She's a voter in that municipality where she is running, but the issue is she's actually a resident of another municipality.
She might be disqualified, Your Honor,
Why?
because mere
Disqualified, cancel the COC?
cancel the COC, mere registration as a voter cannot qualify you for office, Your Honor, in that locality.
Yes, but voter requires a residency requirement.
6 months, Your Honor.
Yes, and she has voted at least once or twice before that election, so that means more than 3 years.
The fact that the misrepresentation has not been exposed earlier is no reason to continue violating the law and to condone her
Even
misrepresentation.
if there has been no petition to exclude her from the voters list of the other municipality,
His Popel does not die against this state. So if those facts are unearthed in a Section 78 proceeding against her, even if there is no exclusion of voters that has been found, she will be disqualified. But this is hypothetical.
yes, hypothetical.
Subject to study.
Thank you. May I have the Tribune of the People? In the meantime, you may get your deserved rest.
Thank you, Justice.
For Harry.
Let me just find out. I don't think there is any more question for the Commissioner. We will be striking and this is the turn now of the Solicitor General. Please approach the podium, Mr. Solicitor General. Justice Bernstein will start the interpellations of the Solicitor General, followed by the other justices.
Yes, this is only going to be brief. The point that you made today is that the petitioner is a natural-born citizen.
Yes,
Okay. Do you agree with the proposition that there is only one kind of natural-born citizen? And that is biologically natural-born.
yes, Your Honor. Insofar as these proceedings are concerned.
So, if the proposition of the respondents that she was not born of a mother or father or both parents who are Filipino citizens is to be sustained, she would not fit the category of a natural-born citizen, biologically speaking.
Well, if the assumption is sustained, Your Honor, it logically follows that she cannot be natural.
All right. May I ask you this? I did not like to ask the Comelec about this because I anticipated their answer already. Whose burden is it to establish natural-born citizenship of the petitioner?
Thank you, Your Honor. I think there are two ways to answer that question. On the assumption that the members of the Honorable Court agree that the intention is to classify foreigners as natural-born citizens, then there is no need to go into presumptions. They are natural-born citizens as if their parentage is in fact established. If the court, on the other hand, is not predisposed to considering that 99.9% is enough, then I would say that at the very least, the person who questions the natural-born status of a foundling would definitely have the burden. Like I said, Your Honor, this is not a 50-50 situation we are facing here. I can provide the certification from the Philippine Statistics Authority, and there is no way that we can dispense or dismiss the 99.9% statistics in favor of anyone who's born here in the Philippines being a natural-born Filipino.
Okay. Here is the petitioner. She filed the COC. She stated there that Commissioner Lim, she stated she was a foundling. Diba? All right. And the commissioner told us that immediately from that statement, the Comelec could presume that she was not a natural-born citizen, and so everybody expected her to come forward with her evidence to show that she was a natural-born citizen, notwithstanding her statement of being a foundling. So, where is the burden of proof?
Again, Your Honor,
Your
Honor, the burden of proof would be when anyone who questions her natural-born status. It might sound counterintuitive, Your Honor, but I would say that a person who has in her certificate of life birth proof that she is a foundling is in fact a natural-born citizen. And I can demonstrate it with a simple example. I agree that a person who presents himself or herself as a natural-born citizen has the burden. And so, for example, a person who wants to run for president claims that he or she is qualified, then the Comelec can very well say, what is your proof? Because there's no such presumption. An ordinary citizen can present an ordinary certificate of life birth showing Filipino parentage. A foundling, on the other hand, can present the same certificate of life birth proving that she is a foundling. And we can supplement that again with statistics. If 99.9% of people born here in the Philippines are natural-born citizens of the Republic, then again, Your Honor, I would say the presumption should definitely tilt in their favor.
So without those considerations, would she fit as a natural-born citizen? Without those considerations you mentioned, considering her statement in her own COC that she was a foundling?
I would say, Your Honor, that it is her fact of being a foundling that establishes her status as a natural-born citizen, given the statistics in her favor.
Okay. Will you tell me again, because I was not listening too well to you a while ago, when you said that a foundling, did you say that a foundling has the nationality of the place where he is found?
No, Your Honor. My approach would be purely textual. The Constitution, or at least the relevant Constitution applicable to petitioner, here in this case is the 1935 Constitution. The only way she can be considered a natural-born citizen is either through constitutional intent, the records of the 1935 Constitution, or if we go simply by the text, whether she can establish Filipino parentage. And I would say that given the statistics in her favor, 99.9%, there is no way we cannot possibly consider her a natural-born Filipino. The Constitution does not require a person to identify a specific Filipino parent. The only requirement of the Constitution is that you be able to establish by substantial evidence your Filipino parentage. And 99.9% should be more than sufficient, Your Honor, than even an ordinary birth certificate which establishes prima facie filiation.
Okay, thank you, Mr. Tribune of the People. What does that mean?
The term, Your Honor, was invented by the Supreme Court for the Office of the Solicitor General in cases where the Solicitor General disagrees with a client agency.
You should wear an epaulet. Epaulet.
Thank you.
Solicitor General, everyone knows that the Office of the Solicitor General is very much knowledgeable in constitutional principles. So I will ask you very simple and basic questions. What is required for a constitution to be effective? Here in the Philippines,
that would be ratified.
Required for the 1935 Constitution, the 1973, and the 1987 Constitution to be effective.
The terms of the Constitution usually provide for a mechanism for its effectivity, and that mechanism is by ratification.
By the people in a plebiscite.
Yes, Your Honor.
Now, when you submit the Constitution in a plebiscite to the people, what is the purpose of that plebiscite?
It's to obtain their consent, given that we are a democracy.
That the people can approve approve the Constitution. That is the purpose.
Yes.
And the people must approve the Constitution with full knowledge of the content of the Constitution. Is it that?
The idea
The
is,
reason for the plebiscite?
well, usually, Your Honor, before the act of ratification, there is a process of publication where the people are informed, but there is no requirement that the people actually know the contents of the Constitution that they are ratifying. It is simply a presumption that they know, given the sufficient amount of publicity involved.
And state your interpretation of the Constitution, which will depend not on the language of the Constitution which was submitted for ratification by the people, but by the deliberation in the Constitutional Convention. Will the people know what the delegates in the Constitutional Convention took up in the course of their deliberation in drafting the Constitution?
It's very difficult at this point in order to unearth the intention of people who ratified the Constitution in 1935. And so our best evidence is the records of the convention. And as I have stated, Your Honor, it's very clear that the status of foundings under the 1935 Constitution was discussed, and that there was a clear proposal to consider them as a class as Filipino citizens.
Do you agree that not a single citizen would have known that it was the intention to include foundlings among the natural-born citizens of the Philippines? Nothing in the Constitution will give that information to the people who ratify the Constitution.
That is an argument we can make for everyone who ratifies any particular constitution, Your Honor. Again, there is no requirement that the people who ratify the Constitution be very knowledgeable of the nitty-gritty of the text of the Constitution they are ratifying. And so we simply go by the text and by the records of the Constitution.
Will you be justified now on imposing an interpretation on our citizenry that foundling are included in the definition of natural-born citizen under the Constitution when there is nothing at all? There is nothing at all that will give that indication in the Constitution when it was submitted for ratification by our people.
I would disagree, Your Honor, that there is nothing at all. In fact, the question that is faced by the Honorable Court in this case is one of fidelity to the Constitution itself. As opposed to the clear records of the Constitution where you can discern an intent, whether possible or not, you have an absolute nothing with respect to the intention to discriminate against them. And so I wouldn't want to impute on the members of the 1934 Convention a discriminatory animus against an entire class of human beings. I would rather consider them as people who are rational and benevolent. And in fact, practical, given that, as I have said, in all likelihood, and this is 99.9%, every founding would have a Filipino parent anyway.
But the point is still, is it justified for us to impose on our people an interpretation of the Constitution which will supplement the language of the Constitution if there is nothing at all there mentioned about founding?
Not at all, Your Honor. I think it's standard work of judges and jurists to interpret the Constitution. And constitutional interpretation is, in fact, the goal of every judge every time we have some dispute. In this case, I would even say the case is absolutely clear in favor of foundings.
So can you say that you can amend the Constitution because of the deliberation of the Constitutional Convention? That is practically what you're trying to do to us, to amend the Constitution because there is such a deliberation on the Constitutional Convention which is not even adopted. It was voted down. And now you want us to impose your interpretation on our people in the absence of any statement in the Constitution about founding, which they never heard of when they approved the Constitution in the course of the plebiscite. You can explain that let us not argue about that, but to inform us what is the weight of the deliberation of the Constitution when the Constitution itself is silent. Are we justified in supplementing the Constitution Constitution because there is such a deliberation which the people never had any inkling at all when they approved the Constitution.
I think, Your Honor, the sort of deliberation is what judges do
Is
on a
the
regular
last
basis.
In the interpretation of Constitution, that is the last thing that you should do. Maybe to clarify ambiguities of the language of the Constitution, you need to go to the deliberation to discover the intent, but never to amend the Constitution and supply something which is not there. Now, if you can find a principle of constitutional interpretation that may say that the liberation of the Constitutional Convention prevails over the language of the Constitution, then you put that in your memorandum.
Yes, Your Honor. What I'm saying is not that the intent of the members of the Constitution can amend or even supplement the Constitution. What I'm simply saying, Your Honor, is that it is the ordinary work of judges to resort to the intent of the framers when trying to shed light on the meaning of a particular phrase or clause of the Constitution. But I will, Your Honor, put that in my memorandum. Thank you.
The people must be well aware of what they are approving. So this court is not justified in just adding language or adding provision into the Constitution, which we cannot justify to have been approved impliedly or expressly by the people in epilepsy. But if you can find any support to your position, then so be it, do it. But in your memorandum,
Yes, Your Honor.
you provided the court with some statistics, but your premise is that the petitioner was born in the Philippines. What is the proof on record that the petitioner was born in the Philippines? What is the basis for your statistics?
I think, Your Honor, that it was in fact assumed during the entire litigation in this case that the petitioner was born in the Philippines because she was a child boy. It was not as if she was a 2-year-old or someone who was able to walk and talk when she was found. She was a newborn baby, or at least a person who was born just almost immediately after sent to the Church of Hari.
Is there anything in the founding certificate which says or give any statement about the age of the foundling when the foundling was found?
I think one of the founding certificates simply assumed that she was born sometime in September 3 of 1968.
She was found on September 3, 1968. Nobody personally knows when and where she was born.
That is true, Your Honor. I'm not counsel for petitioner, and so I suppose the counsels for petitioner can provide more factual details in the memo as to the circumstances of her supposed.
You gave statistics, and your premise is that the petitioner was born in the Philippines.
Yes, Your Honor.
You're citing statistics about how many persons born in the Philippines will have nationality. But the point is, there is nothing on record that will give us any evidence that the petitioner was born in the Philippines. There's nothing there. The birth certificate, ordinarily, the birth certificate will give that information because that is supplied by the hospital, by the midwife, or by the parents of the child. But here, I have not seen any evidence that will show that the foundling was born in the Philippines. There's nothing there. So, how can you use the statistics?
Given the lacuna in the evidence, we need to go by common sense. I would really find it difficult to assume that foreigners would come here to the Philippines and leave their children behind. That is really totally unheard of. And so, in the absence of any evidence, we go by what ordinarily happens here in the Philippines.
But what ordinarily happens, but you have no empirical basis or any factual evidence to support your conclusion.
I think, Your Honor, that in this litigation we need to dispense with the idea that we can know who her parents are, when she was born, exactly what date, because because that is exactly the given in this particular case. And so,
What was given is that she was found in a church in Iloilo on September 3, 1968. There is no evidence at all whether or not she was born in the Philippines. And you cannot, there's a dearth of evidence on that point. So you cannot use your statistics. It's not impossible to say a child was born in Hong Kong.
I'm not even sure if someone can transport from, say, the United States a newborn baby into the Philippines.
You don't even know.
But like I said, because I'm not counsel for a petitioner, they can probably give you the more specific nuances to
Yes, but the thing is,
how young she was when she was found in Haro.
yes, but there's no evidence at all as to the age of the child, whether she was a week old, 2 days old, or just been born. There's nothing, it's just the certificate that she was found in Haro, Iloilo on September 3, 1968. That's all. So we do not know where she was born.
My assumption, Your Honor, was that she was...
At what age she was found? We don't even know.
My assumption, Your Honor, is that she was born here in the Philippines, and if that can be disputed, then my entire presentation falls. So I'm willing to state my entire presentation on the fact that she was born here in the Philippines.
Yes, but the court will want to rely on what is on record, whether we can...
And I submit that to the majority of the members of the court.
And as I mentioned, the fact of birth can be tested too competently by the hospital, by the midwife, or by the parents of the child. But here, clearly, there is no such evidence. We do not know. She was found.
That is the reality of the situation now, that we are dealing with a founding. And so it would be totally irrational for us to search for things that cannot be found.
So I'm just mentioning this because of your presentation on the statistics about persons born in the Philippines, when I cannot find any evidence that the petitioner was born in the Philippines.
Yes, like I said, if someone can prove the petitioner was not born in the Philippines, then my entire presentation falls and would be useless for purposes of these proceedings.
Now let's go to the order of approval by the Bureau of Immigration. Now, the implementing regulation issued by the Bureau of Immigration mentioned that the approval by the BI can be revoked by competent authority upon the substantive finding of fraud, misrepresentation, or concealment on the part of the applicant. Now, what do you say to the fact that the applicant for dual citizenship under RA 9225 here concealed the fact that she was adopted, that she was found?
I think, Your Honor, that was already answered by the presentation of the Chief Justice, that we have the right to, that an adoptee has the right to rely on her adopted parents as her parents in every official document that she can sign.
She was adopted in 1974. At that time, there was no law allowing the issuance of an amended birth certificate that came long after she was adopted. But if I recall, the amended birth certificate was secured just about 2 months before she applied for repatriation under RA 9225. Now, what is the legal consequence of that belated amended birth certificate, which was issued decades after she was adopted?
None, Your Honor.
It seems to be the purpose seems to be to use the amended birth certificate in
applying for 9225.
So I would say so.
You think so? You think so?
I'm sorry, Your Honor.
I'm sorry, it was the counsel for the petitioner who mentioned that they did not use the birth certificate, they used only the passport. Am I right? You said that she submitted only the passport, so she did not make use of the amended birth certificate. So she used only the passport. Now, so we would like to find out the validity of the order of approval of the Bureau of Immigration when there is a concealment of the fact that the petitioner or the applicant there was not do not have any biological ties with the supposed father or mother who are Filipino citizens. Now, the implementing regulation also required the commissioner, specifically mentioned that it should be the commissioner of immigration who should issue the order of approval. Now, there was another officer of the Bureau of Immigration which issued the order of approval of the petition for under RA 9225. Now, what is the implication of that on the validity of the order of approval? And there is the express requirement that it should be the Commissioner of Immigration who should issue the order of approval.
Your Honor, these are proceedings to determine the validity of the Comelec's cancellation of petitioner's certificate of candidacy. I don't see any relation of that with a possible collateral attack on proceedings before the Bureau of Immigration.
I'm saying here that it's actually any competent authority can revoke the order of approval upon finding of the fraud, misrepresentation, or concealment.
I'm not aware of any competent authority, Your Honor, that has in fact revoked that prior certification.
This court being not a competent authority to pass upon the validity of the order of approval of the Bureau of Immigration.
Your Honor, the court can only act on cases and controversies, and the case before you right now is with respect to whether or not the Comelec committed grave abuse of discretion in cancelling petitioner's certificate of candidacy. The Bureau of Immigration is not even an impleaded party here, and so I cannot understand the relevance of any attack on whatever it is that they've done a decade ago in this particular proceedings.
But this issue is necessarily included on the issues raised before us. There is a question about the validity of the order of the Bureau of Immigration granting, in effect, dual citizenship to the petitioner here.
No relevance at all. The issue, Your Honor, here is whether or not petitioner is a natural born citizen. The members of the Honorable Court can answer that in so many ways without even resorting to the proceedings before the Bureau of Immigration. This is a question of constitutional interpretation, a question of whether or not you can rely on facts and statistics as presented by my office and certified by the Philippine Statistical Authority.
Despite the fact that the claim of natural born citizenship as an eligibility to run for the presidency is based, you can trace it back to the application for repatriation under RA 9225. That was the source of all of this. So can we not go as far as that to determine whether or not she is qualified or eligible to run for presidency? Because it was a series of
separate issues. Whether or not she is a natural born, and I would say that is the intent of the 1985 Constitution, whether or not a former natural born, when repatriated, recovers her natural born status, that is already a decided case, Your Honor, being zone. And so I would find it strange for the court to reverse a standing decision of the court just so they can disqualify one particular foundling. I suppose the court might also be interested in potential reputational damage that the court would suffer in having to reverse an existing jurisprudence just to disqualify a candidate for the president. I would advise it, Your Honor.
But I should say the court can always reverse ruling that it has done.
That is a given, Your Honor.
Especially if there was a dissent or there are dissenting opinions. In the Benson case, there was a dissent by Justice Gutierrez, and she upheld the decision rendered in the merit by Justice Melo and Justice Vito. These are the eminent justices of the Supreme Court who were then members of the House Electoral Tribunal. So,
I might be biased,
this
Your
court
Honor.
would be justified in looking at the ruling in the Benson case again, when there are steering dissent made by Justice Gutierrez, citing Justice Melo and Justice Vito.
Like I said, Your Honor, I might be biased, but I would consider Justice Mendoza, the Pinete in the HIUT case as a rather eminent constitutionalist. And again, Your Honor, I would expect that the first defenders of the majority decisions of the Supreme Court would be the Honorable Court in Bank itself. I think it's essential to the operation of the rule of law that the current members of the court strongly respect previous majority decisions of the court, even if they were not members of that court, and regardless of the number of dissenting opinions. A majority is a majority.
But the Constitution is a living document, and it has to take into account the present situation, the environment, the social, political, and economic environment to discern the underlying principles in the Constitution. So the decision was a long time ago. The Benson case was decided
Benson is 2011.
quite a long time ago.
Age by itself, Your Honor, is no ground to reverse. And I would say that the Constitution being a living document doesn't provide any normative compulsion for the Honorable Court to reverse itself. You don't reverse yourself just because you think that the Constitution is a living document. And if at all, Your Honor, RA 9225 is a positive sanction of the decision in Benson, because Benson was decided in 2011, RA 9225 is 2013. That is essentially a coordinated branch of government agreeing with the interpretation of the Supreme Court that those who are able to repatriate themselves should be able to recover their natural born status. And that's two departments of government, Your Honor. I would consider that a very weighty.
You look at the provision of that law again, and I think it is silent on what type of citizenship is regained or reacquired. Retention perhaps is something else, because when one is naturalized, during the effectivity of the law, this person, this Filipino citizen, will be naturalized knowing that he or she can still retain Filipino citizenship. But the one who was naturalized before the effectivity of the law has no idea at all that she or he can retain Filipino citizenship. That's why there is a difference in the language of the law.
I think, Your Honor, that analysis is precluded by the intent of the framers of that law itself. I think the Chief Justice resorted to statements made by Senate President Raymond about the intention. And again, the larger policy concern here, Your Honor, is about the nature of our embrace of our returning Filipinos. Like I said, we don't see them as potential traitors to the Republic. In fact, in the Exod, Your Honor, the returning citizen there was a former member of the military, whereas RA 925 is even broader. It covers those who have not served in the military of another country. And so, if we wanted to adopt a jingoist attitude towards returning residents, we should have done that in Benzon, not in RA 9225. Whereas in RA 9225, you have an even broader embrace for returning residents.
Again, to your stance that this court can always add something to the law or to the Constitution, even if they are not found in the language of the Constitution or the law, but you're always relying on the liberation, which did not find in the language, which was not able to be, which was not incorporated in the law or in the Constitution. Apart from the deliberation that you mentioned, there's nothing in the law or the Constitution that will support your conclusion that this position of yours are considered adopted by the framers of the Constitution or the law.
I think, Your Honor, it was Professor Lawrence Stein who said the Constitution is a framework, not a blueprint. We cannot possibly expect the Constitution to provide for every contingency, for every situation that would require its own interpretation. And so I have never doubted, I don't think the court has ever doubted the need to resort to the intent of the framers when dealt with some uncertainty. Also, I think, Your Honor, that my position is not to add to the language of the law. My position is that foundings are national-born citizens because their parents are in fact Filipinos. And so I don't see that as supplementing or adding, it's actually providing meaning to the current language of the Constitution.
Our main thesis is that the members of the Constitutional Convention thought that foundlings are already covered by international law. That's why they did not mention any more foundlings in the Constitution. So you are relying not on a factual basis, but on a deliberation of a Constitutional Convention which was not submitted to the people for ratification or approval. That is your main thesis. You want us to supplement the language of the Constitution, which is by something which is found in the deliberation of the Constitutional Convention, which was not at all brought to the attention of the people who ratified the Constitution.
I think, Your Honor, we can go for the jugular here. We can simply ask, does a person, a foundling, have a Filipino parent? And I'd say, if that person has a 99.9% chance of having a Filipino parent, then that solves the entire problem.
Can you base it on your premise that the child is born in the Philippines?
Well, of course, Your Honor.
But as I said, you need to point to any evidence on record to show that the petitioner here was born in the Philippines, and I have not been able to find any.
I'm sure Your Honor, Petitions Council would provide more details in their memorandum.
Justice Garcia.
Counsel, the Constitution says that
If Your Honor, I'm not counsel for anyone here.
Mr. President of the people, Constitution says that the Philippines adopts the generally accepted principles of international law as part of the local land. What do you understand by general principles of international law? What is the meaning of that?
Well, my my understanding is that these are the general rules of interpretation, general rules of justice that have been accepted by international tribunals.
This refers to principles of law that are so fundamental that you find them in almost all legal systems of the world. They're virtually in all legal systems of the world. So when you say general principles of law, the universe is the world. It's not regional law, correct? It's not the regional principles of law. It refers to general principles of law which are so fundamental that they are found in almost all legal systems of the world.
Yes,
so those principles of law that we adopt as part of Philippine domestic law do not refer to principles of law that can be found only in the Indian subcontinent, correct?
Correct.
Or in the among coastal countries in the South China Sea, correct? It has to be the world as a universe, correct? International law is divided into customary international law and regional international law. What do we follow as part of domestic law? Customary international law or customary regional law or both?
Customary international law.
It has to be international. The universe is the entire world, correct?
Yes.
So, when a treaty says that the treaty shall take effect when 25 countries have ratified it, supposing all the countries that ratified it were very tiny countries, would it matter?
Well, it depends, Your Honor, on the person who's trying to read the situation.
There are 100 countries who signed it. And there is a provision in the treaty which says the treaty shall take effect. If 25 of the 100 countries will ratify this, then the treaty takes effect. Will it matter if only small countries ratify it, or it must be representative?
Well, Your Honor, it would depend on your view of international law.
What is the basic rule in the United Nations? The basic rule is there is sovereign equality among all its members, correct? Whether you're a small state or a big state, you have one vote, correct?
Yes.
So it really does not matter.
Well, that is the formal position, Your Honor, but we
ICC Council, Tribune of the People, you know that the ICC has not been ratified by Russia, by the US, or China. Big countries refused. But it did not prevent the ICC from taking effect, correct? Because all states have sovereign equality under international law, correct?
Yes, Your Honor.
One vote, one state, correct?
Yes, Your Honor.
So it does not matter as long as the number of states have been reached, the treaty takes effect, correct?
Yeah, in theory, like you said.
Okay. Now, how does the Constitution define natural-born citizen?
Well, it depends on the terms of the Constitution itself. Yeah. If you're referring to our Constitution, then
yes,
we can refer to the 1935 Constitution, the 1973 Constitution,
the present Constitution,
the 87th Constitution.
The present Constitution.
Natural-born citizens are citizens of the Philippines from birth without having to perform any act to acquire or perfect their citizenship.
Okay. Let us assume that an infant is found, 3-day infant is found today in front of the Manila Cathedral. The infant has blue eyes, black eyes, milky white skin. The parish priest looks around and doesn't find anyone claiming the child. So the parish priest goes to the DSWD, turns over the child to the DSWD. The DSWD conducts an investigation, a formal investigation to find out if the biological parents are around, if they can be found. Nobody comes out. So the DSWD issues a foundling certificate. Okay. What is the nationality of the child? Is the child a natural-born citizen of the Philippines?
I would consider the child a natural-born citizen of the Philippines because 9% of the time, that child will be a natural-born citizen.
So even if the child has blue eyes, blonde hair, Caucasian skin,
it's possible for Filipinos to have blue eyes,
blonde hair,
It's possible.
How many percent?
Again, Your Honor, if we're looking
How
at
many percent of Filipinos, natural born, have blue eyes, blonde hair, white skin? 99.99%.
I don't know about the
That's
specific number.
0.001%. You don't have the statistics.
I'm sorry, Your Honor.
You don't have the statistics. You don't have the statistics of Filipinos who
I don't, Your Honor, I don't.
are born with blonde
Out of the 0.0001%, Your Honor, I don't.
You don't.
I don't.
So you would say that every child born in the Philippines who has blonde eyes, blonde hair, white skin, whose parents cannot be found, and there's a certificate by the DSW that's following. They are all natural born citizens of the Philippines.
Your Honor, I am not threatened by people with blue eyes and
But my question is, what is the nationality of those children, of those infants?
natural born Filipinos still, Your Honor. If you don't have access to their actual
Supposing now there is a DNA taken from the child, you say they are natural born citizens. The DNA shows that they have Caucasian genes, no Asian genes at all. Would you say they are natural born citizens of the Philippines?
Well, it's possible for Caucasians to be Filipinos, Your Honor, and natural born Filipinos.
If their parents are Filipinos.
Yes, exactly.
But if you don't know who,
And I then would go back to 99.9%, which is a rather comfortable number for me.
but how many percent of Filipinos have blue eyes and blonde hair and white skin?
That is an irrelevant fact for me, Your Honor. I'm not looking at the class of citizens.
You have to look at the statistics also on the other side.
I'm sorry, Your Honor.
You have to look at the statistics also.
Yes, Your Honor. Of course.
So it's really impossible. Almost 0.001% a Filipino would have blonde eyes, blonde hair, white skin, but you still consider them to be Filipino citizens, natural born.
Absolutely, Your Honor. Because again, if you have no other choice but to
Even if the DNA results show that they don't have any Asian gene, they are still Filipino.
I would be comfortable with that policy result, Your Honor. If I am able to do justice to the 99.9% who are in fact of Filipino parents and be very generous to someone who happens to be blue-eyed and blonde, I would embrace that blue-eyed and blonde child and consider him a natural born Filipino.
You said that
I can speak with that fact, Your Honor.
You said that natural born citizen is one who does not have to perform an act to acquire or perfect Philippine citizenship. Is that correct?
Yes, Your Honor.
Now, this founding had to go through an investigation by the SWD because you are not a foundling until you go through this process, correct?
Yes, Your Honor.
So, unless you have a founding certificate, you cannot be deemed a foundling, correct?
Yes, Your Honor.
So, that is an act that is required, correct?
Not at all, Your Honor. That is a process that is for the purpose of declaring that founding in founding. That is not an act for acquiring or perfecting one's citizenship.
But if
The
you are
moment a person is declared a founding, you consider him ipso facto a natural born citizen. But foundlings don't try to get founding certificates just so they can establish their natural born citizenship.
Unless the child has a founding certificate, you cannot give her Philippine citizenship, correct?
Well, prior to that declaration, you don't know the status. But the moment a person is declared a founding, then ipso facto you have to consider him a natural born citizen.
The founding certification is necessary before you can declare him a natural born citizen.
For administrative purposes. Your Honor, I think this today is
Without the founding certificate, can you say that child is a natural born citizen?
Again, Your Honor.
Without the founding certificate, can you determine the nationality of the child as natural born?
Without a founding certificate. For what purpose?
My question is, without a founding certificate, you just found a child now, blue-eyed, blonde hair, 3 years old, 3 days old. Can you now say that child is natural born citizen of the Philippines?
Well, if that child is born in the Philippines, I would say that child is 99.9% a Filipino and a natural born.
Without the founding certificate.
The moment we issue a founding certificate, I would say ipso facto, we also consider him a natural-born Filipino citizen.
But why will you say that the child is a natural-born citizen when you still have to determine whether the biological parents are around or not? You have to go through an investigation.
Yes, of course.
Yes, so if you find a natural, a three-day-old, blue-eyed, blonde-haired child here, you don't see any parent, you cannot say that she is a foundling, correct? Because you have to. Yes. So if you cannot say that the child is a foundling, you cannot say she's a natural born per your theory.
Your Honor, I don't look at people and determine whether or not they're natural born or not, simply because they.
Yes, but you said that a foundling is automatically a natural born citizen of the Philippines.
Yes.
But you forget that before you can be a foundling, there must be a certification, there must be a process.
Yes,
that is an act.
There is
That is
an
required.
act to acquire or perfect. I think
That is an act to perfect, because without that you cannot have citizenship.
I think that matter is already settled by Coquilla, Your Honor, by the decision of Justice V.V.
That
Mendoza.
didn't include foundling.
Justice V.V. Mendoza, an act to acquire citizenship is an act of naturalization. An act to perfect one's citizenship is the election process under the 1935 and the 1973 Constitution.
Does that mean
The language of the 1987 Constitution actually tracks the language of the 1935 and the 1973 Constitution.
did that case involve foundlings?
No, Your Honor, but that involved a question of what it means to acquire or
Did
perfect.
the decision say that that is the only meaning of an act to acquire or perfect? There can be no other.
I'm comfortable with that reading, Your Honor.
Yes, that's correct. But did it say that that's the only way? There is no other way.
I think that was what was intended by the 1987
Could not have been that way because the facts there limited it to the issue.
And
I don't think it was foundlings.
I don't think, Your Honor, that when the 1986 Constitutional Commission were drafting the language of the Constitution with respect to natural-born status, that they were in fact thinking of foundings. When they wrote the terms in the Constitution, the
You
language,
are saying that the silence of the Constitution doesn't mean that it's not included. Now you're saying arguing the opposite.
I think, Your Honor, that the language of the Constitution is already fully exhausted.
Okay, let's go to the silence of the Constitution. Let us say the Constitutional Convention, there was a proposal that the following shall be natural-born citizens of the Philippines: A, B, C, D, and E. They all voted. A got the majority, B got the majority, C, D got the majority. E was rejected. Okay, so if you read the Constitution now, it says the following natural-born citizens: A, B, C, D. Only A, B, C, D. Okay, there's no E. It is silent on E when you read it. Is there silence of the Constitution in that case?
It depends. That factual scenario is entirely different from what happened in 1934.
Now, wait, we're not getting into that situation. Is there silence of the Constitution in that case?
Yes, Your Honor, of course.
Silence. So E is still can be interpreted to be included in the enumeration even if it was rejected in the convention.
It depends on context, Your Honor. If we're referring to the 1934,
No,
that is exactly the context.
I'm not talking about the 34 yet.
Well, the problem, Your Honor, is we're dealing with hypotheticals.
Okay.
And you're trying to get
We should do a clear example. The same thing. The following natural-born citizens of the Philippines: A, B, C, D, and E. Approved entirely. Nothing was mentioned about E during the convention. Can you say that E is included in the enumeration?
If it's there textually.
It's not there because it was not discussed in the convention, it was not voted upon, so you cannot see it in the final copy.
Okay.
So is E part of the natural born?
Again, Your
Because of
Honor,
the silence of the Constitution.
we can only make a conclusion based on the facts. And the facts are in the 1934 convention. And if you want, I can provide you with the facts, Your Honor. The proposal of
In other words, I'm telling you, I'm asking you, counsel, can you say that the Constitution is silent when in fact the convention discussed it, put to a vote, and it was rejected. Now you are saying, oh, the Constitution is silent when it comes to founding. But the founding issue was discussed, deliberated, voted upon, and it was lost, and it was rejected. How can you say rejected is part of the Constitution?
What was rejected, Your Honor, was the proposition that foundlings be explicitly recognized as Filipinos.
But how many of them supported that proposition? How many? How many delegates?
I would assume, Your Honor, that since the proposal
You
was
are assuming. What? I'm asking you exactly. How many delegates supported that?
I don't
You
know.
wouldn't know. There was only 2 spoke in favor of that.
But that's how conventions go, Your Honor. You don't require
Yes,
everyone.
that's why you cannot take those speeches as the thinking of the majority. So you have to go to the voting.
If we do away with the deliberations, we might as well throw out all the deliberations of the 1935, 73, and 87
Yes,
Constitution.
you look at them as guides, but they will not be controlling because each delegate talks differently.
Yes.
But if there is a voting, that's conclusive, correct?
Yes, of course.
Is there anything more conclusive than a voting?
Well, the meaning of the vote, I would say that would be conclusive.
Thank you, Counsel.
Thank you, Mr. Justice Clark.
The matter of registration of foundings, I just want to follow up from Justice Carpenter's questions. They are found in different parts of our statutes, right?
Yes, sir.
Have you noticed that the registration of foundings are found in the same parts as the registration of children of known parents?
No, Your Honor.
They are. Actually, when you go through the domestic registration laws or domestic adoption laws, founding certificates, the duties of the DSWD, etc., you will find out, in fact, that all of these are just considered as registration procedures.
Okay.
Can you, with known parents, avail yourself of the benefits of Filipino citizenship without an administrative action acknowledging that your parents are Filipinos? In other words, do you need your birth certificate to enroll?
No, Your Honor. The birth certificate only furnishes you with a comfortable paper that's provided in a
Do you
class.
need it in order to get your passport?
Yes, Your Honor.
In other words, is it not just an administrative act of registration and not really an act of naturalization?
Yes, Your Honor.
In fact, can you find the word naturalization there in any of the systems describing the process of registration of foundlings?
I don't think so, Your Honor.
Why not? They're all in the arena of registration of children, whether they are children of known parents or children of dependent, of abandoned, neglected, or unknown parents. So these are acts not performed by the foundling himself, but by whom?
Either by the parents or by the state for the child.
In fact, you are not the one who applied for your own birth certificate, right, Mr. Solicitor General? You did not. For yourself.
At the first instance, Your Honor, I did.
Yes, because somebody else witnessed your birth. So it was an act that you did to acquire your citizenship in the same way that foundlings do not perform an act in order that they can be registered as foundlings.
That is right, Your Honor.
Okay, thank you. Justice Aguilera has a question, and then Justice Perez. Yes.
Who does the foundling register himself as a foundling?
That would be a very funny situation, Your Honor.
Justice Aguilera, please.
More senior justice.
And then Justice Reyes and Justice Leonel. Okay, Justice Reyes, please.
It's just what with the very basics. This is just a general and fundamental consideration subject to the compilation of the Western Pacific General. As it is, the present case is Poe-Llamanzares,
under 64 relation to Rule 65 of the Rules of Court. I placed for assailing the December 1, 2015, and of the resolution of the second division of the Comelec and the December 23, 2015 resolution, rather the Comelec second division, and the December 23, 2015 resolution of the Comelec. So, inarguably, the decision rendered by the Comelec and bank could be overturned or reversed only because if the Comelec greatly abused its discretion amounting to or excessive restrictions on where the Comelec is guilty or has been performed this week, etc. So to speak on options. Being pursued under the rules on certiorari, the Comelec may somehow commit some mistakes or errors in the appreciations of facts. And evidences, nonetheless, such decisions itself is not flawed, unless, as I have said, there was an abuse of discretion, etc. Yes, so you confirm that Mr. Solicitor confirmed that it was only when the Comelec did commit great abuse of discretion or fraud that the basis for denying or disqualifying grace. Yes. So I have heard and listened to all arguments, evidences, positions of all the parties. And I think that will be enough. So I wanted to write Mr. Solicitor General that it is not a question of whether evidence, arguments, which it is. So it's a question of whether Comelec has committed great abuse of discretion amounting to excessive restrictions or was found to be guilty of fraud, etc. Yes, Your Honor. Thank you, Mr. Justice.
Justice Lenin, can I just follow through with those points, Honorable Chair?
Yes, Your Honor.
Just very few brief points. How many generations of ancestors does the Constitution require to be assessed before we can say that the descendant is natural born?
Just one.
Just one.
Yes.
In other words, we do not need to go to a second generation, the grandparents.
No need.
Not the great grandparents, only one, the fathers and mothers. Okay. Can a French male be a naturalized Filipino?
Yes.
Can a Lebanese woman become a naturalized Filipino?
Yes.
Can a French male that is naturalized Filipino fall in love with a Lebanese woman who is now a naturalized Filipino?
Yes.
Yes. And can they give birth to a blonde, blue-eyed, fair-skinned baby?
Who is a natural born?
And that baby that is blonde, blue-eyed, fair-skinned can be natural born.
Yes.
Yes. So, if somebody lives a fair, blonde, blue
in the steps of the Supreme Court newly born, it is possible that it is natural born, correct?
Yes.
If it is left behind in swaddling clothes, etc., then it can be also natural born. Is that
Yes.
okay? Can we stipulate that there are blonde, blue-eyed, natural-born Filipinos actually?
Again, sorry.
Wait, can we stipulate that there are Filipinos with brown hair?
Yes.
Yes. And among the people in the court now, can we stipulate that I have brown hair? Very difficult. Okay, but in any case, the point there is that there are certain characteristics which are uncharacteristic of a stereotype of a Filipino that others possess. Is that not correct?
Correct.
Yes. By the way, is Senator Grace blonde?
No, Your Honor.
Does she have blue eyes? Would you know?
No, Your Honor.
Have you looked into her eyes?
I've read the pages.
Readings. And is she fair-skinned?
Reasonably fair.
So we are not talking about a blonde, blue-eyed baby left in the Manila Cathedral or in front of the Supreme Court steps. We're talking about a baby that was left in Haro, correct?
Yes, Your Honor.
By stipulation by the parties, did they admit that it was a baby that was found?
I think so, Your Honor. Yes.
In fact, the date that she was found is the presumptive date of birth, correct?
Yes, Your Honor.
September 3. So it must have been like a newborn baby, is that correct?
Correct, Your Honor.
Yes. And that newborn baby, could it have come from China? Thrown in from China, put in Haro, in the cathedral.
Within the range of possibilities.
Is it probable?
No, Your Honor.
Is it probable that it came from Malaysia?
Yes, Your Honor.
Possible? Probable?
No, Your Honor.
Is there an international airport in Haro? At that time, in 1960,
I would have to look at this if I knew something like that.
yes. In any case, perhaps you get my point with respect to that. Now, let's go to a bit of math. Okay. Filipino father, there are 4 cases. Filipino father, Filipino mother, correct?
Yes.
That gives rise to a natural born. Filipino father, non-Filipino mother, natural born. Second case. Filipino, father not Filipino, mother Filipino, third case, natural born.
Yes,
Not Filipino father, not Filipino mother, 4. Not natural born, correct? Yes. Could be naturalized later, correct? Of the 4, 3 cases are presumptively Filipino, correct?
Yes,
And the only case is a very unique one, a foreign father and a foreign mother, correct?
Yes,
Did I get you correctly when you said a foreign father and a foreign mother would less likely leave their offspring in Haro, Iloilo at that time in 1968?
Yes,
And in fact, you went into statistics which you will present to the court. Is that not correct?
Yes, Your Honor. We have the certification.
Okay, next. The word in the Constitution is residence, correct?
Yes,
But we interpret it as domicile. Is that not correct?
correct, Your Honor.
Did you amend the Constitution?
No, Your Honor.
Did we supplement the Constitution?
No, Your Honor.
We interpreted it, correct?
Yes,
The word in the Constitution is equal protection of the laws, correct?
correct, Your Honor.
Do you find in those words the 4 elements of equal protection?
No, Your Honor.
In fact, it is People versus Kayak in 1938 which introduced the 4-way test. Is that right?
Yes, Your Honor.
My God. Did we amend the Constitution?
No, Your Honor.
Did we supplement the Constitution?
No, Your Honor.
Did we interpret the Constitution?
Yes,
Due process of law. There is procedural and substantive. Is that found in the Constitution?
no, Your Honor.
It's due process, correct?
Correct.
Yet it is this court that doctrinally, in fact almost canonically now says that due process consists of 2 other adjectives, procedural and substantive. Is that correct?
Correct, Your
Did we amend the Constitution?
No, Your
Did
Honor.
we supplement the Constitution?
No.
Did we violate the rule of law?
No, Your Honor.
Okay. JDC. A representative of Congress. Correct? Did this court say that is 1/2 congressman and 1/2 senator? Chavez versus PCAG. Did we amend the Constitution?
No, Your Honor.
Did we supplement the Constitution?
No, Your Honor.
Of course, that's not the same.
Of course.
course. But in any case, the point there is that's what the court does. Interpret the Constitution in cases where it is not clear-cut, correct?
Correct.
For a founding, is it very clear-cut that you can name the father and the mother?
No, Your Honor.
But the Constitution does not say name the mother, name the father, correct?
No, Your Honor.
Fathers or mothers, correct? So you are confronted with a situation where the Constitution provides the parents, but you have to apply it to a unique situation not covered, correct?
Correct.
Yes. Okay. So therefore, it is not to amend the Constitution, but to interpret it. Correct? And it's not violative of the rule of law, correct?
Correct.
Because there is a Supreme Court. Otherwise, this will be composed of computers, correct?
Correct.
Not human beings that look at actual cases and read words in the Constitution. Correct?
Correct.
And words change meaning in accordance with the context. Is that not correct?
Correct.
In the 1900s, the question of founding may not have been as important as it is now. Is that not correct? So therefore, there are instances where the words in the Constitution created in 1934 or 35 will not be applicable now considering the different circumstances. Isn't that correct?
Correct.
Yes. Okay. It is a constitution we are expounding. Have you heard those terms?
Yes.
Yes. In fact, there is an entire book written, and the title is It's a Constitution We Are Expounding. Can you expound on what it means?
Yes.
The Constitution is not a statute. It is not a regulation. But it is comprised of broad statements where it creates a Supreme Court, a legislature, an executive, and several other constitutional organs that contribute with each other to interpret the words in the Constitution, correct?
Correct.
And that it is a living document, correct?
Correct.
It cannot be dead. Although Scalia, who says that it is not a living constitution, is not dead, correct? Yes, correct. The point there is that it's a constitution that we are interpreting. It has to live at the moment and address certain situations that arise, correct?
Correct.
Yes. And it's a whole constitution, not particular words, correct?
Correct.
And it is not only fathers or mothers that we have to interpret, but the entire constitution taken together.
Correct.
Now, intent versus actual constitutional precept. In terms of constitutional interpretation, which takes precedence? Actual constitutional norm versus intent. Which one?
I would have to look at the facts of every case.
The constitutional norm, if it is there, you have to start with that interpretation, correct?
Yes.
Our constitution does it have the word social justice?
It does.
Does it have the words human rights and human dignity?
It does.
Article 2. Does it protect the youth?
Yes.
Does it protect the youth's participation in public affairs?
It does.
Yes. Does it include the right of the family to protect its children?
It does.
And can that therefore give rise to the state also protecting the children in the context of a family?
Of course. Yes.
So it's not only isolated at the provision on citizenship. Is that not correct?
Correct.
All of this can come into play because ultimately it's a constitution that we are expounding. And we protect the constitution, not particular words, correct?
Correct.
Yes. Okay. Finally, the respondents have considered that with respect to residency, physical presence, and animus munendi has been established, at least with respect to the Comelec. They already considered that. There is a third element, and the third element is animus non-libertandi. And I'd like to confront you with that. The senator came here in 2005. She did not renounce her citizenship the moment she stepped out of the commercial airline she came. Therefore, there is always animus non-libertandi. Animus non-libertandi is not present because as an American citizen, she knows that she can always go back to the United States. Do you agree with that?
Again, Your Honor, I'm sorry.
In 2005, May, she stepped out of a commercial airplane, landed in the Philippines. In fact, May 24, if I'm not mistaken, 2005. Correct?
Correct.
That moment that she stepped out of that airplane, she did not renounce her American citizenship.
No, Your Honor.
Therefore, she did not have animus non-libertandi because with the American citizenship, she can always return to the United States. Can you respond to that?
Again, Your Honor, go back to the the decisions of the Honorable Court that would separate entirely the question of residence and citizenship. Entirely separate considerations here.
But she had an American citizenship, which meant that if anything went wrong in the Philippines, she can always go back to the United States. Therefore, she did not really have that element, animus non-river family. Is that what it means?
No, Your Honor.
What does animus non-river family mean?
It's basically the flip side of animus munendi. In fact, they're just different sides of the same coin because you can only be present in one particular location. The moment it is established that you have an intent to remain in that place, it follows that you no longer have an intent to return to
Domicile mean that you will never change your domicile ever.
No, Your Honor.
Thank you.
Thank you, Justice Jordan.
Justice Mendoza.
Mr. Tribune of the People, the statistics that you cited, is that from the web or do you have other evidence?
Your Honor, we got it from the Philippine Statistics Authority. We have an official certification from the Philippine Statistics Authority, and I will provide the court with the certification. I apologize for having raised it belatedly. I was able to get the certification only yesterday.
Thank you. So, will you please do that?
I will, Your Honor.
When did you become acting Solicitor General?
Long time ago. August, Your Honor, the day after you were appointed to the court.
And so you have been when you became full Solicitor General, and that would be around what?
May last year, Your Honor.
Almost more than a year and a half, right?
Yes, Your Honor.
And how many times during that term did you act as Tribune of the People?
Formally, Your Honor, I'd say twice. In other cases, without referring to ourselves as Tribune of the People, we have disagreed with client agencies.
And I noticed a while ago in answer to Justice Bersamin, you mentioned that this is a very Philippine invention. The American Solicitor General, for example, is not called in certain circumstances a Tribune of the People.
Yes, sir.
When you act as Tribune of the People, essentially you disagree with your client.
That is the usual indicator, Your Honor.
And what would be the other indicator?
Well, under the charter of the OSG, the Solicitor General can intervene in any matter that affects the interests of the Republic. It would be another instance, Your Honor.
Ordinarily, a lawyer, an advocate, will have to represent his or her client to the best of his ability, right?
Yes, Your Honor.
The privilege given to you to be a Tribune of the People is one of a kind because you are given a privilege to disagree with your client.
Yes,
and without violating your duties as an advocate, right?
Yes, Your Honor.
And of course, you can even disagree with the executive department.
Yes, Your Honor.
Which in effect, you can disagree with the president who appointed you.
Yes, Your Honor.
So, when a Solicitor General, for example, disagrees that certain provisions of a law are unconstitutional, in effect, you're disagreeing with the person who appointed you.
Yes, Your Honor. Because the president signs law.
And so that makes that privilege a very awesome privilege.
Yes, Your Honor.
And you do that, you don't do that every day.
We do it sparingly, Your Honor, because, well, we assume that Congress and the President were able to perform their functions, and in fact, almost all of their acts are constitutional. There is a presumption that attaches to it, but of course, in certain cases, we recognize that the charter of the office requires us to be both independent and autonomous. And so our jurisdiction is to be both independent and autonomous, which requires us in certain cases to disagree with and with.
That is why by your charter, the charter of the OSG, and your sworn duties and your responsibilities under the law is that if you, in conscience, disagree with an agency or even branch of government or even the executive branch, you can disagree and you get the designation Tribune of the People.
Yes.
In those rare instances, you are acting on your conscience for the people.
Yes, Your Honor.
You are allowed to do that.
Pursuant to my charter, Your Honor.
Of course, you can be fired by the president.
Yes.
Yes. Now, in the SET case, who asked you to represent the SET?
It was the SET, Your Honor.
And after you represented the SET in another case, you went to this court and told this court you were accusing yourself, right?
With respect to the Comelec.
To these Comelec cases.
Yes, Your Honor.
And what did this court do?
The court, in its advisory, required me to appear anyway, Your Honor.
In effect, this court, despite your offer of recusal, directed you or forced you to come before this court to act as tribune of the people.
Yes, Your Honor.
In effect, this court wanted you to examine your conscience and tell this court what you feel about all the issues of this case.
Yes, Your Honor.
And what you have said today comes straight out of your conscience and the conscience of the OSG.
Well, yes, Your Honor.
Thank you.
Thank you, Your Honor.
Justice De Castro.
Just one point.
Yes, Your Honor.
Earlier you mentioned the thesis of Justice Mendoza about the persons who can be considered as naturalized Filipinos.
Yes.
What you mentioned. So let's go back to the constitutional provision. Insofar as this case is concerned, there are only two provisions which are relevant. The first one, which concerns the natural born citizenship of those who are born to a Filipino father or Filipino mother. And that is clearly natural born citizenship.
Yes.
The other classification is those naturalized minor.
Yes.
So, anyone who would like to claim Filipino citizenship, which does not fall under the first category of natural born citizenship, must point to a law as a basis to claim Filipino citizenship.
Yes.
So, in the case of a foundling, it does not, the foundling would not claim Filipino citizenship based on the first section of the Constitution, but from the submission of the petitioner, the foundling claims Filipino citizenship on the basis of international law.
Your Honor, that was the submission of the petitioner. My position is that given that the statistics are so overwhelmingly on the side of petitioners, it supplements my position that the intention is correct, or that at the very least she is entitled to a disputable presumption that she is innocent.
What is your legal basis? You state your legal basis for making that proposition. What is your legal basis?
The Constitution, Your Honor. The Constitution considers as natural born Filipino someone who has a Filipino parent.
You agree that the first category of Filipino citizens are those born to a Filipino mother or a Filipino father.
Yes.
Now, the family does not come under that classification.
In fact, Your Honor, the statistics say that they do.
No, you cannot, can you use the statistics as a basis for claiming citizenship? Is that your proposition? One can claim citizenship because of statistics?
Absolutely, Your Honor.
That is your position as Solicitor General. Do you know what you're trying to say to this court? Everyone must have a legal basis for a position that will be advocated before this court, either the Constitution or statutory law. You cannot say that we will rely on statistics.
I am saying that, Your Honor.
So your basis is the statistics that you mentioned?
Well, my full basis, Your Honor, is that number one, you have the records of the 1934 convention. They clearly intended to consider foundlings as natural-born Filipinos.
So it's not
If you don't agree, Your Honor, with the intent, I have the statistics. If the general question is, do they have Filipino parents? I'd say because they have, by statistics, 99.9% possibility of having Filipino parents, then you might as well consider them natural-born Filipinos. Any other interpretation would be unfair, discriminatory, and unjust. You would be sacrificing the political rights of an entire class of people because you are obsessive compulsive about absolute certainty.
Solicitor General, do you know what you're trying to do? You are mentioning things before this court which was not even considered by the Constitutional Convention. They did not talk about statistics. They did not talk about possibilities. Now you want us to consider the citizenship of a foundling based on that, which is not found even in the record of the Constitutional Convention.
I think Your Honor,
it's not at all mentioned. Now, as Solicitor General, when you put forth a position, don't you always state the legal basis for your position? I'm asking you for a legal basis. I'm not asking you about the statistics. You state to this court your legal basis for saying that foundlings are considered natural-born citizens.
I think, Your Honor, that when Sr. Raffles proposed that foundlings be considered Filipinos because their parents are Filipinos anyway, he was relying on his gut sense that in all probability, foundlings are in fact of Filipino parentage. What I'm giving you, Your Honor, the Honor Court is an empirical basis for that gut feeling.
Now, you should be candid to this court. The members of the Constitutional Convention mentioned international law when they were discussing this. So it was based on international law that they thought was existing at that time. So it's not about probabilities, it's not about statistics, there's nothing of that sort in the deliberation of the Constitution.
There were three positions in the 1954 Convention. The position of Mr. Raffles, that they be considered Filipinos because their parents are Filipinos. The position of Senor Montenola, that under domestic law they are Filipinos. And the position of Senor Rojas, that under international they are Filipinos. And so, what you have, Your Honor, is a total agreement among all those people who are conversing that they ought to consider foundlings as Filipinos. The only debate was how to do it. Should they do it expressly or impliedly? The vote was to reject the Raffles proposals, which simply meant that Montenola and Rojas won. And that is the only thing that you have, that's the only thing that we can go by. The other proposition has absolutely no basis. That there was some members of the Constitutional Convention who were malicious, that they wanted foundlings excluded from the Constitution. There is absolutely no evidence of that, Your Honor.
What was the petitioner and you are trying to convince this court to use as a basis to determine the natural-born citizenship of the petitioner is the discussions which dealt with international law. My point here is that there are two kinds of citizens under the Constitution. One, citizens by birthright, which is by biological tie to a Filipino father or mother. There is no question that is natural-born citizenship. And the other classification is naturalization by law. Now, we have a law which there is a naturalization process through judicial proceedings, and that is provided for by law. That is generally understood as acquiring citizenship by naturalization. That is using the provision of law, which will allow courts to grant Filipino citizenship. Now, the other one is a presidential decree issued by former President Marcos, which allowed the Office of the Solicitor General to conduct administrative proceedings to grant Filipino citizenship. Again, that is based on a law, a presidential decree. Now, we have laws granting, special laws granting Filipino citizenship.
to prominent persons that may have contributed something worthwhile to our society. So there is again a law granting citizenship to individuals. Now, in the adoption law, that is another law which recognizes foundling to be Filipino citizen, which can be validly adopted under our law because the law only allows adoption of Filipino citizen. So, for a foundling to claim Filipino citizenship, that foundling must invoke the adoption law. There's again another law that is the basis to claim Filipino citizenship. Now, if we go by the position of the petitioners, they are invoking customary international law, principles of international law. So there is a law that they want to invoke. So all of these types of process to acquire Filipino citizenship would have legal basis, and that is a law that must be invoked, and that can come under the broad concept of naturalization by law. As long as you acquire citizenship by invoking a provision of law, you are a naturalized citizen by law, and you cannot invoke citizenship under the first provision of the Constitution, which refers to biological ties to a Filipino father or a Filipino mother. So when you mention the principles that were discussed by Justice Mendoza, he was citing examples of how one can acquire citizenship by law. So I'm asking you, what is your legal basis to say that foundlings are natural-born citizens? By what provision of law? By what provision of the Constitution? Don't just rely on statistics. Don't just rely on probabilities. Don't rely on possibilities. Because citizenship is a question of law. It's not a question of possibilities. It's not a question of statistics. And as a Solicitor General, you do not argue that way before the Supreme Court. You provide us with solid legal basis for your proposition.
If I may give an example, there is no evidence that any member of this Honorable Court is 100% natural born. No member of the Honorable Court applied for a position in the Supreme Court providing DNA evidence. The only evidence that all members of the current court provided is their birth certificate, which is only a prima facie proof of their Filipino affiliation. Is that absolute certainty? Absolutely not. What kind of certainty? I don't even know. 80%, 90%, 95%, I don't even know. And so, what I'm saying, Your Honor, if you're worried about probabilities, what I'm telling the Honorable simply is that the entire institution rests on probabilities. We rely on probability as a matter of law, because otherwise, it's pointless to conduct scientific inquiries to determine DNA evidence for every person who is applying for a position requiring natural-born citizenship. And so, what I'm saying, Your Honor, is if you have a 99.9% probability that every child born in the Philippines is a natural-born Filipino, you need not worry, because that might be higher than the prima facie evidence that is applicable to members of the Supreme Court and all persons who are required to establish their natural-born affiliation.
But you know, there's no one questioning our citizenship. And we have our parents who testify. And we have documents to show. Documents that came from the hospital. Documents signed by our parents. So,
but that is
let's say that we are relying on probabilities. There is no one questioning our citizenship. And if there is anyone doing that, or who would like to do that, then we will be ready to present credible evidence. But don't equate our situation with the situation of the petitioner here, which admittedly has no one to testify or to prove that she was born to a Filipino father or a Filipino mother. That is completely different from the situation situation that you mentioned. In fact, I was saying earlier that the birth certificate is a credible and competent proof because it is signed by the hospital is required to submit within 5 days the certificate of birth of everyone born in the hospital. A midwife must submit a birth certificate to the local civil registrar. The parents too should execute a birth certificate to prove that the child is their own. But here, we're talking about a foundling whom we do not know whose parents we do not know, where she was born, at what age was she found in Haro, Iloilo. There are so many things that are not present here. And most probably, if the mother would come out and say, she's my child, that will be credible evidence, and so she may have to testify where the child was born, what are the circumstances of her birth. That can be credible evidence if somebody, the mother of the petitioner will come out and say that I am her mother. She was born in this place on this particular date. That will be credible evidence. If she can establish the hospital where the child was born, it need not be a DNA. There are so many ways of proving the citizenship of a family. If only one relative can come out and claim the petitioner to be a relative and to explain the circumstances of her birth, even without the DNA, if the totality of evidence presented will show that she indeed is the mother, then the court can rely on that. So, do not equate the situation of the petitioner with anyone of us here or anyone in the audience. We all have our birth certificate duly authenticated.
The point, Your Honor, that I was trying to make was that for purposes of applying and holding public positions requiring natural-born citizenship, what is only required is a birth certificate, which is only prima facie proof of the facts that are stated therein. That, I would say, is simply probabilistic because we rely on the bureaucratic process, not because they are absolutely true. On the other hand, Your Honor, you have a 99.9% probability. I would say I'm just as comfortable with the 99.9% probability as with a new birth certificate that is shown to me by someone applying for Supreme Court or the presidency.
Certificate under our rules and under existing jurisprudence is credible evidence. And until it is attacked or proven untrue, then that can be considered as sufficient proof of our citizenship and of our relationship to our father or mother.
Yes, Your Honor. That's why I say if the question is mere sufficiency, I'm okay with the birth certificate. I'm just as okay with the 99% probability.
So my point again is this. Please provide us with a legal basis for your proposition that a foundling is a natural-born citizen. It must be founded on the Constitution. It must be founded on a provision of law because that is the only thing that is good to accept. A legal basis for your proposition that the petitioner is a natural-born citizen.
You said, Counsel, that in the 1934 Constitutional Convention there were three positions. Montimola said that foundlings under domestic law, natural-born citizens. Rojas said foundlings natural-born under international law. And the third was the position of Raffles, who said that foundlings are presumed to be natural-born. Is that correct? Correct. And the position of Raffles was rejected by the convention, correct? Correct. So there are only two, according to you. That foundlings are natural-born based on domestic law, and foundlings are natural-born based on international law. We have to, you're saying now that the proposition that foundlings are presumed to be natural-born have been rejected by the 1934 Constitution. That's what I was saying. No, Your Honor. There was no debate, Your Honor, as to whether or not they should be considered Filipinos.
The debate was the level of recognition. Should it be based on the text or implied?
That's what I'm saying. There were three positions.
Yes.
And the position of Raffles was rejected. But you spoke about and rejected, correct?
Yes.
And that position was, according to Raffles, he wanted to include in the Constitution a provision that foundlings are presumed to be natural born.
Are Filipino citizens.
Foundlings are Filipino citizens.
And therefore natural born.
And therefore natural born. So foundlings are natural born.
Yes.
That was rejected.
Yes.
So we're only now, according to you, you can consider only two views. That foundlings are natural born because of domestic law, or foundlings are natural born because of international law.
No, Your Honor.
Under the 35 Constitution.
Under the 35 Constitution, all of the proponents were in agreement that foundlings are Filipinos. It was the method by which they should be recognized.
But the position of Raffles, you say, was rejected.
And that position was for an express recognition. The two other guys won implied recognition. There's no other evidence.
So no other guy said the basis is domestic law or international law. That presumption.
The two other guys said there's no need because they are already considered Filipinos.
And then what is the legal basis for them?
According to Montinola, under domestic law, according to Rojas, under international law.
So those two won. That's your position. Those two won.
Exactly.
So you have to look at whether Montinola is correct and Rojas is correct in their...
Your Honor, the only question is whether or not they won, not whether or not their legal basis were wrong.
Why are you saying they won when they did not put their proposal to a vote? Why are you saying they won when they did not put it to a vote?
Your Honor, it is safe to assume that when the members of the convention voted, they voted on these two proposals. An express recognition.
There was only one proposal put to a vote. The proposal of Raffles. Who said that?
Yes, Your Honor.
So the proposals of Rojas and the proposal of Montinola were never put to a vote.
Of course, Your Honor.
You cannot say whether it won or it lost.
Again, Your Honor.
You cannot say that the proposal of Montinola and Rojas won or lost because it was not put to a vote.
What I'm saying, Your Honor, is that when they rejected the Raffles proposal, they basically agreed with Montinola and Rojas. And that's the only way to explain it.
That's an
The
implication.
only possible way to explain it, Your Honor.
No, the other way there is that foundlings cannot be considered natural born.
What is the evidence for that? No one ever said that.
They rejected because the amendment of Raffles is they are presumed to be. Whatever is the basis, they are presumed to be.
What I'm saying, Your Honor, is that no one in the convention in 1934 ever came out and said unlike foundlings, they should be discriminated against. What would happen in the
Agreement Council that the Raffles proposal was rejected. And this proposal was that foundlings are presumed to be natural born.
are recognized as
Filipinos and therefore natural born.
Yes.
And that was rejected.
Yes.
Okay, thank you, Council.
Thank you, Mr. Justice.
Justice Perez.
Answering from all the discussion, that the only thing that we are sure about is that the proposition that a foundling is not a natural born citizen is an undecided proposition until this moment. Am I correct?
Well, of course, Your Honor.
That being so, can we say that the petitioner Poe, when she mentioned that she is a natural born citizen, was committing a false representation when up to this moment we are not even sure that a foundling is not a natural born citizen. She may or may not be a natural born citizen. In other words, there was no truth yet by which to measure the representation of Poe as false. Am I correct, Mr. Tribune of the
Well, that's a logical statement, Your Honor. Thank you, Mr. Justice.
Mr. Solicitor General, do you know the work of the Style Committee during Constitution making?
Yes, Your Honor.
I happen to be a part of the 1999 Preparatory Commission on Constitutional Reform.
Yes, I am aware of that, Your Honor.
And after all the reports the various committees were brought in, it was given to me to harmonize all of the provisions. And one of the key principles is that if it is not necessary, in other words, if it is not needed to be explicated because it is a constitution, then we do not need to explicate it. Is that the correct principle?
Correct, Your Honor.
Because it is a constitution that we are making. And not once did we say that simply because a proposal to explicate a specific provision, for example, ownership of the mass media, and there was a proposition to break it down further into the advertising industry, into the broadcast industry, into the print industry. There were proposals there that we should enumerate and extend it to all the specific restrictions to each and every kind. Now, when we came to a consensus that in fact we all understood the principles that we wanted, which is to leave it to Congress to legislate nationality restrictions, when we came to that understanding, we rejected the proposed amendment to specify or explicate. Did it mean that we rejected the provision that we are going to leave it to Congress, the limitation of the nationality provisions to the print industry, the broadcast industry? Was that what we did?
No, Your Honor.
So it was a matter of style. In other words, when we understood that it was sufficiently clear to us what our intention was, because there was no opposition on the intrinsic validity of the proposal to leave it to the legislature to provide for the restrictions of the nationality, then we said the shorter the better.
Yes, Your Honor.
Did we mean to reject the proposals?
No, Your Honor.
The proposals remain.
Yes, Your Honor.
And they are valid.
Yes, Your Honor.
And nowhere can you find a consensus to reject those proposals. And that means that we believe we understood what we meant.
That is true.
Is that not the way, in fact, that you read constitutional records?
That is the way to do it, Your Honor.
Now, let me ask you again also. When we talk about presumptions, the presumptions that populate our laws, our statutes, are they not all products of probabilities?
They are, Your Honor.
In other words, we cannot live and have rules and do with our business with regularity if we do not base our actions on probabilities.
Yes, Your Honor.
In fact, numbers mean something to us.
Yes.
It even, to a democratic form of government, equates majority rule to the basic form whereby consent is generated. Is that not correct?
Correct, Your Honor.
So numbers can in fact form a legal basis.
Well, as Holmes would say, we measure our existence based on imperfect knowledge.
Yes, because that is the only way we can live by common sense.
Yes, Your Honor.
So when we talk about our future as a court, I was earlier adverting to a conversation I had with the international law jurists and lawyers. And let me go further and tell you what they said. We cannot imagine a modern country like you, where your Supreme Court will say foundlings are not Filipinos. And they were saying that the repercussions will be so broad and so deep because this may be the first occasion for the highest court of any land to make a pronouncement on the matter. Do you think that what he was saying makes sense?
It does, Your Honor, because the current membership of the court are the stewards of its own institutional capital.
Now, when I already outlined so many administrative provisions that act on the basis that foundlings are presumed to be Filipinos, when I
play two Supreme Court decisions where the court saying that their parentage, pronounced that their parentage are not known. They may have been seen, but it doesn't establish that they are Filipinos. And then one said that the founding is a Filipino. When I read the title of two adoption laws that includes foundlings as among the Filipino children that can be subject to domestic adoption or inter-country adoption. Are you saying that the totality of these administrative actions, judicial actions, and legislations have no constitutional basis?
All of those, Your Honor, have weighty constitutional value. The acts of Congress, for example, they are congressional selection to an understanding of the Constitution. And so anyone who reads and interprets the Constitution would be well advised to consider the acts of the coordinate departments in treating in this case, a particular class of human beings.
Now, with respect to my last question, when you talk about the residence of petitioner here, and that the court has always uniformly considered residence to be determined by actual residence and by the intent manifested by specific acts, did the court, in fact, when it allowed the domicile theory to be the predominant theory and not to be regulated by what is the form of the paper or whatever other characterization is animating that state, is the court in fact acting within its bounds in having had a long line of jurisprudence that focuses on actual residence?
Yes, Your Honor. The jurisprudence on residence goes back to as early as Falcon versus Merino, the 1930s case, explaining what residence means.
And if the Comelec, for an unclear reason, suddenly turned the screws on one person who has already submitted so much documentary evidence on actual residence, long-term residence, is it committing grave abuse of discretion?
Yes, Your Honor.
Thank you, Counsel.
Thank you, Madam Chief Justice.
Considering that there are no further questions,
Chief,
Justice Santasillo? Yes, sure.
Can I just address three questions to Attorney Valdez?
Justice De Castillo, can we defer for now to Justice De Castro who wants to ask one question from the Solicitor General? May we request you to return to the podium, please? Justice De Castro would like to ask you something.
One question. The petitioner concealed from the very start that she was a foundling, that she was an adopted child. That was, I think from the start, from the time that she applied to repatriate under RA 9225. This fact was concealed by the petitioner all throughout. It was only at the time that it was questioned when a petition was filed before the set questioning her citizenship that she disclosed that and admitted that she was a foundling and that she was adopted. Now, what will the court, how will the court consider this in terms of her good faith or bad faith in making allegations that she was born to a Filipino father and a Filipino mother? This non-disclosure or concealment of this fact, why did she conceal this when she applied for repatriation? Did she know that it will cause her some legal problem or legal controversy? That I'm just asking you to explain to us it cannot be considered as an indication of her bad faith.
Thank you, Your Honor. I am not aware of any constitutional or statutory requirement that a foundling disclose his or her status. And so, as a practical matter, I don't think it's a status you would want to be proud of or ashamed of. It's just not something that you are required to disclose. So
It's applying for the benefits of a granted to natural born citizen, and the checklist state that she must show that she was born to a Filipino father or a Filipino mother, and that she should also state the citizenship of her parents. But instead of disclosing the true circumstances of her birth, she decided to conceal. Was she aware that it will cause some complication, legal complication, that her application will be denied, so that she had to conceal these facts, which are very material in the case of her application for repatriation under the law?
Again, it's a bit difficult to go back in time and say what are the things that I could have done. But I'll just go back to my original question. I don't think there's any particular requirement for her to make that disclosure. And number two, if I were a foundling, I would consider myself within my constitutional right to consider myself a natural born citizen. That would be my position.
But that is not what the application from that she filled up to apply for repatriation under the law. The questions posed before her was very clear and explicit. It was about the circumstances of her birth. And that will be the very basis for the approval of her petition for repatriation of her dual citizenship. So it was a material fact that she should have disclosed, but she did not. Why did she not do it?
If I will go back to the record so that I can answer that in my memo.
I guess I'm telling this to you because I would like to find out if that is material to determine whether she was in good faith or bad faith.
I will answer that in the memo.
That started from the very start, from the time that she applied for repatriation, where the concealment was done. That was the very first time the concealment was done, and which initiated a process that led to her being considered as a natural, which led to her assertion that she is a natural born citizen. All of what happened after that were the fruits of her initial concealment that she has a foundling and unadopted child.
Okay.
Thank you, Minister Solicitor General, for your patience and for your having stood as tribune of the people. Yeah, the same requirement for submission of simultaneous memoranda is also imposed on you. So we will now call on Attorney Amado Valdez, whom Justice and Castillo would like to ask some questions to.
Good evening, Your Honors.
Good evening, Counsel. Among the four respondents, you're the only one who mentioned about the 2014 assets and liabilities of the petitioner. On page, you mentioned the assets and liabilities of the petitioner in your petition for not to give due course COC or the cancellation of the COC. There you mentioned that the petitioner maintains that her assets and liabilities. You mentioned that she maintains 2 residential houses in the U.S. one which he purchased in 1992 and the other one in 2008. Is that correct answer?
Yes, Your Honor. I did some internet research, and this was confirmed by her own statement of assets and liabilities.
What was your purpose in bringing that to light?
Well, we thought, Your Honor, please, that because there were two competing domiciles, we are looking at it from the standpoint of private international. When she acquired Filipino citizenship without renouncing her American citizenship, during that very critical period, she was in a status that is inimical to the interests of the country, as per the Constitution. There was a competing interest on the part of the U.S. claiming her as a domiciliary of the U.S. and the Philippines claiming her as a domiciliary of the Philippines. That's why it's very critical that your decisions in Cotilla, in Caballero, in Hudson, in the previous cases, in Halusos, that the most relevant date when a person will be considered to be domiciled in this country is when he renounces his American citizenship. Because with that,
yes, I understand now what you're driving at. What I'm trying to clarify from you is, what is the relevance of your mentioning there that the petitioner still maintains two residential houses in the States, one which he purchased in 1992 and the other one in 2008. Does it have something to do with the petitioner selling her family home in April of 2006? In other words, are you saying that, okay, so she sold her family home in the States in April of 2006 to show that her reacquisition of domicile in the Philippines is imbued with animus laboratory. Is that what you're...
There is still the presence of animus laboratory by the fact that she still maintains substantial asset and result residences in the United States. Plus the fact that she used her passport for 5 times. And
yes, the other matters. I just want to focus on the real property. That because she sold, that's what she's saying, that she sold the family home in April of 2006. Fine. It would seem that you're abandoning already for good your intention to remain in the States. But then you still bought a residential house in 2008. Is she maintaining these two? Is it your position? Are you trying to tell us that she's still maintaining these two real properties in the States?
Precisely, Your Honor, because she has been a resident of the U.S. In fact, for about 19 years. So it could not be easily understandable that by selling her properties and establishing a residency, yet leaving some properties that could be telltale signs of wanting to still remain in the U.S. would negate whatever manifestations or acts on her part that she has chosen to stay in the Philippines.
Thank you, Hassan.
Thank you very much.
Can I just clarify? You're basically saying a natural-born Filipino citizen to be considered as completely loyal to one's country cannot acquire properties outside the country?
Now, what I was saying, please, is we have two completing domiciles. And for this court to make a choice.
But for a particular person who has only one citizenship now, who
because it is considered she has only one citizenship now, right?
From all,
Now.
yes, all.
And she maintains assets outside. Does it count? Because she's staying here. Does it mean that all of us, all elected officials, cannot acquire properties outside even if they are actually domiciled here?
Yeah, that's
Because there will be competing allegiance. Is that what you're saying?
what I'm saying, Your Honor, is that until she renounced her citizenship, there are still signs that there are strings attached to her feet to stay in the U.S. And therefore, you cannot say for sure that she has already changed her domicile, because domicile is something which
But in all the jurisprudence of the court, we have never taken it against a person if there are still assets outside of the place of domicile. I don't remember.
we do not question that your place. What we're questioning is, she cannot say without contradiction that between 2006 and 2010, she has already decided to make the Philippines as her domicile. That's why I was saying in my opening statement that the Comelec was even liberal in considering July 2006 as the start of the counting for her.
Notwithstanding the transfer of all her household belongings.
Well, not necessarily.
Notwithstanding the schooling of the children. Simply because there were still assets left in the U.S.
Well, I know of many American citizens who are staying in the U.S. They send their children here because they
But
think.
she's not staying in the U.S. and she stayed since May 2005. So you're saying, even if she stayed since 2005, even if her children started studying here and they never left it except for short vacations, even if they sold all their household goods, brought home all their pets, brought home all their cars, because they have still assets, you still do not give credence to them.
You credit those things in favor of Philippine Jew domicile. But what I'm saying is there are other circumstances that you can credit in favor of U.S. domicile. Remember that those circumstances which you credited in favor of Philippine domicile only satisfied animus manendi in physical places of the Philippines, but she failed to complete the third element, which is animus non libertandi. I think the law jurisprudence says that you have to complete all these three circumstances in order to have changed your domicile.
Okay, so can we close the proceedings for the entire consolidated cases of the Comelec and your discharge? Because unless there's any further question from any of my colleagues, thank you, you're hereby discharged. And may I request all the council, plus the Tribune of the People, to kindly rise for your instructions. May I just repeat what had been said earlier, that you have 5 non-extendable days, which means Monday, close of business hours, to simultaneously serve your memoranda on each other and also to file it with the court. After which, these cases are deemed submitted for resolution. This session is hereby adjourned.